Item 1, CA1 of 2025.
My lord, I am appealing for the petition.
Leadership, I am raising the point of maintenance.
CA1 of 2025.
Yes, first
Yes.
matter.
Ramesh Mandor.
Ramesh
Yes.
Pandit.
On the earlier occasion, you were not representing.
No, I was.
On 13.
Junior.
Yes, my junior.
Okay. Yes.
May I proceed? My lord, can you come to
Your
please?
Lordship, as I have raised the point of maintainability, so I may be permitted to raise it first, Your Lordship. Otherwise, it will be tedious. All merit we are entering and afterwards we are finding that it is not maintainable. Your Lordship, I filed the application under Order 39, Rule 1 and 2 for repair of the premises. That application was disposed of.
Okay. Against the order of rejection, they have come up.
No. Again, my application was allowed. Against that, they have come.
Okay. So injunction, prayer for injunction was allowed,
Allowed.
against which they have come up.
Yes. Now it's an appealable order.
Application
Under Order 43, Rule 1R.
and 2
Hmm.
for injunction.
Hmm.
But the learned trial court passed order permitting the opposite party to repair the suit premise.
Order 39, Rule 1 and 2 is for that purpose only. Injunction of any kind. How he can say that it is
And
not
my
an injunction?
application restraining
It's an
the
interim
opposite
order.
party is not to make any construction, that is pending. And I filed application first. My application was pending, but the
Let it
subsequently.
be, Learned Council, let it be heard out.
Yes.
You know,
But page number 35 is the deed of lease.
1 minute.
Page number 34. Well, this is a deed of lease, unregistered, unnotarized.
Issue book. The thicker ones. The thicker ones.
This deed of lease, neither registered document nor notarized. It is a simple deed of lease. My first submission is this deed of lease is non-est in the item.
Learned Council,
I'm coming
this
on.
is civil revision.
Yes.
Then we will have to be confined within that aspect only.
Yes.
We cannot go and hear out the entire, as if we are hearing the appeal. We are not hearing the appeal. We have to be confined within that impugned order.
I'm confining myself with that part.
Impugned order.
Yes. Input. Let us start from the input order section. Input order. After page number 122. 35 something.
Dated 8/11/2024,
Yes,
order number 10.
order number 10. I'm reading the order.
Yes.
There is the commissioner report and the material on record. In view of the fact that the inspection report is in resonance with the points that were asked for to be inspected and no challenge is raised regarding the inspection report of the commissioner, I am inclined to allow the petition dated 22/7/2024. Accordingly, the petition filed on 22/7/2024 under order 13 rule 1 and 2 read with section 151 of CPC is allowed on condition and defendant have given the liberty to repair that need for immediate repairing at their own cost. This would property in accordance with the petition so that extent as reflected in the inspection report of the planet commissioner. Defendants are directed to keep in mind the repairing works supposed to be made would not give rise to claim of equity on their part in the pending suit. Defendants are further directed that they do not have any permission to make any new construction or additional construction to change the nature and character of the suit property in the case of repairing work. Now
Let
can we come to
Let
the
me,
commission?
let me go through one thing. In the meantime, you find out the application in respect of which the impugned order has been passed.
Yes. That is the page number one.
Learned counsel, you place it, let me go through. Yes.
Page number 90 is that application. 90. Which are order 13 rule 1 and 2 read with section 151 of CPC.
Yes.
Now this sought for repair of the two premises. And what is the repair work? It has been mentioned at paragraph 11, page number 90.
So an application under order 39, rules 1 and 2, read with section 151. This is the nomenclature.
Is sought for repair, which is mentioned at
What is the
paragraph 11.
prayer?
Prayer is at page number 95. Committed, with justice of necessary order by allowing the defendants to repair the premises in the manner stated at paragraph 11 of this.
Is therefore
application.
that you honor the pass necessary orders by allowing the defendants to repair the premises in the manner stated at paragraph 11 of this application in the interest of justice. Okay.
Paragraph 11 may be seen at page number 92.
Yes.
11A to 11R, up to page number 94.
So you have
This temporary construction has been made in the year 2000,
through the paragraph 11,
11A to 11R.
you have stated the details about the repairing work to be done.
Yes.
Yes.
Now, this temporary eco-friendly huts and temporary construction has been made in the year 2011. Lease period expired in the year 2021. They are still possessing the land and refuse to vacate the. Now, this point shows that everything has been damaged. Even the commissioner report itself shows that there is nothing to repair and new construction is required. Now, these are the points.
Commissioner report, have you challenged?
No,
Have you challenged the
no,
commissioner?
whatever the things are there, the commissioner report correctly submitted the request.
Well, can you produce the?
Yes, yes,
report
I
of
have
the
it.
commissioner?
I have inputs. Page number 118.
118. Wherein the commissioner has stated that it is to be
Itself,
reconstructed after demolition.
no, it was not stated.
No,
It was
no,
stated.
Which, no, which point, which line you are pressing upon?
119.
No, 119,
I am
which
showing the.
line?
I am showing
Yes,
the.
yes. Place that relevant portion.
The question number one, whether the roof and floor of the reception has to be repaired by replacing the tarpaulin by roofing sheet, whether the woods of the floor are damaged, those are to be replaced, whether electrical equipment have to be replaced and fresh wiring has to be done. Yes, the roof and floor of the reception has to be repaired by replacing the tarpaulin by roofing sheet. The woods of the floor are damaged and those are to be replaced.
No,
and
wherein it is mentioned, wherein in the report, it is mentioned that,
My lord, the
that it is-
application for repair.
no, that it is beyond repair. Wherein it is mentioned in the commission report.
I am submitting that point.
Hmm.
Application filed for repair of the premises. Now the commissioner submitted report, no, it cannot be required to replace.
Wherein it has
Replace.
been mentioned.
First paragraph 119, first question it is replaced. Answer is given. Last,
The woods of the floor are damaged and those are to be replaced.
replace, not repair.
Yes,
Replace means
I've got
it
it, I've
cannot
got
be repaired.
I've got it.
Yes.
Anything
Now,
more?
next point, the answer, all the points up to R, all the points the commissioner has submitted that it is to be replaced. New wiring is required. I am coming
According
on
to
after
your
that.
submission, the entire structure is dilapidated
Yes,
and it is to be replaced.
Replaced.
Entire structure is to be replaced.
yes,
According to your submission.
yes, yes. Not only
Is
my
that-
submission, my lord.
No.
It is stated by
No,
the.
no, no, no,
commissioner
no,
also.
no.
It is stated by the commissioner also.
Herein, I am not at one with you. The commissioner has stated this portion, this portion, this portion, this portion are to be replaced. Not the entire structure is to be replaced.
Whatever the question raised
Let us,
in
let
the
us,
application,
yes.
after commission work has been done, he has given the report in respect to the question raised. Now, next point.
But Learned Counsel, that stage is over.
Yes.
That stage is over.
Yes.
You cannot come up, approach this court as regards to the commissioner's report,
I am not challenging the commissioner.
because
challenging.
that stage is over.
That's I am not challenging. Nobody challenged. Nobody challenged. Whatever found by the commissioner, he submitted the report. Now, this report all over. At the time of inspection, no kitchen room was found. Next, the housekeeping room, which was made of bamboo walls and sheets, has to be replaced by roofing sheets, tin sheet, and by plywood walls. During inspection, it is found there is a temporary structure of fencing which is made by some wood posts. Now, there is no main gate made up of the wood. Then hot water boil has got damaged. Then office room, which is covered by tarpaulin, has to be replaced by sheets. Then the balcony of room number 1 to 5 are made out of concrete material, and the same is now damaged and has to be repaired. There was a corridor which is made up of wood is damaged and needs to be repaired by using new wood. Then there is no electric work. The entire electric works to be carried out by the replacing the old one with new one, such as electrical boards, main panel, board, etc. So this report shows that entire structure is dilapidated condition. So this has to be either repaired or replaced. Now, what happened here? Lease deed. I am not lease deed expert in the year 2020. They are in unauthorized occupation. I issued a notice to remove the
Learned counsel, we shall have to be confined within the impugned order. We cannot go beyond that.
my submission is that when
We are not hearing the first appeal.
my lord, my submission is that whether who are in unauthorized occupation of my landed property, they can be permitted to repair or replace or make any construction over there.
Has that been decided?
They are in unauthorized occupation.
Has that been decided?
Yes, by issuing notice. Notice issued, they have given the reply. And in the reply, they have imposed. They given the reply that as it is
Notice-
expired 2021, come forward for a new lease deed.
That is your contention.
No, it is there in the notice and their reply also. Reply they have stated.
Yes, that is the issue which is to be dealt by the trial court.
Yes.
But this court is only confined only to the application, Order 39, Rule 1 and 2, read with section 151 of the Code of Civil Procedure, and the impugned order passed.
Now, when I filed the suit for recovery of possession, along with that, I filed an application under Order 13, Rule 1 and 2 for temporary injunction, seeking direction against the opposite parties hearing not to make any construction there. My application is pending. But subsequently, they filed application under Order 13, Rule 1 and 2 for repair of the premises. That was allowed even without giving any opportunity of hearing. My written objection was also not there. Report was submitted.
So the court that you were not given any opportunity of hearing.
There is no written objection.
Learned counsel on verbal submission, we cannot go.
My
The
lord,
court will have to be apprised by any document.
there is
by
no
document.
order passed in to that respect. Only no order has been passed. The date 8/11 date was fixed for acceptance of the commissioner report. Commissioner report was accepted. And because none of the parties opposed the commissioner report. Then the trial court has to fix the date for hearing of
Learned
this
counsel,
application.
learned counsel. They had filed an application under Order 39, Rules 1 and 2, and read with section 151.
Yes.
Whether it is correct or not, that is the issue. On the basis of that application, in support of their contention, they have filed another application. They had filed another application under Order 39, Rule 7.
Yes.
That Order 39, Rule 7 was heard on contest.
Yes.
It was allowed.
Yes.
Thereafter, the commissioner was appointed. Commissioner has filed the report. The commission took place in your presence.
Yes.
Now, it is raised that today is the date fixed for order. Learned counsel, can you produce the order number 9?
Order number 10 was for acceptance of the,
Learned advocates for the contesting parties are present.
Yes.
Learned advocates for the contesting parties are present, means
argument was held on that day in respect to the commissioner report. Whether anybody is having any objection to the commissioner report or not.
your submission is exactly in contrary to the judgment, to the order. Today is fixed for order. Does it mean hearing?
No,
So that's why the court is seeking the order number 9.
but this is my letter. Hearing unauthorized occupation without giving any opportunity, without my written objection against that application, whether trial court can pass the order allowing the, and what will be the fate of my application under order 39 rule 1
You
and 2?
show that you were not given the opportunity.
My lord, what will be the fate of my application? It has become infractuous. My application for restraining them not to make any construction. When they have been permitted to make construction over the suit property, my application has already been rendered infractuous. If the court fix the date, my application and their application simultaneously, I can understand.
Can you produce any document revealing that you were not given the opportunity to submit as regards to order this application?
If opportunity is given, certainly I would have filed the written objection.
No, Learned Counsel, your verbal submission is not being accepted. Produce the order number 9.
That case, my lord, can, my lord may.
Learned Counsel, can you produce the order number 9? That it was heard. The court seeks that this application has been disposed of on contest.
Yes, yes, yes.
Can you
It
produce?
was heard. Just a moment. It's not order number 9, it's order number 6.
Maybe.
It's, I have got it. He was heard and thereafter order was passed. It is clearly mentioned that an advocate for the plaintiff raised formal objection. Kindly note it. And that order has not been challenged by him. Formal objection. Order 39.7. उसका बारे में पूछ रहा हूँ।
At the time of hearing of Order 39, Rule 7, you are heard. And Order 39, Rule 7 was taken up. I find another petition has been filed by the defendant under Order 39, Rule 7, Civil Procedure Code for holding local inspection. To my considered view, the petition under Order 39, Rule 7, CPC should be heard at first, which will facilitate the court to decide the injunction petition filed by the plaintiff as well as the defendant. So Order 39, Rule 7 has been heard.
Yes.
Thereafter, learned counsel, thereafter, at the time of hearing of the Order 39, Rule 1 and 2, filed by you.
Yes, was disposed of. Order number 10.
At that time, in their presence.
Yes,
the-
Your Lordship.
You produce, thereafter the order number,
Presence.
order number 7, 8, 9. Order number 7, 8 and 9. This is
That-
order number 6. He has filed order number 10. What is the
7,
7, 8 and 9?
I don't have it. 7, 8, 9, I don't. Might have been adjourned.
What date has been fixed for hearing of that?
Let me see, Your Lordship, if it is online available.
Yes, it will be available online. It has been updated, uploaded. Herein 21/8/2024 for filing receipt of payment of cost and requisites.
That for commission.
Commissioner.
Payment has been made,
That
that is completed.
We can get the. Uploaded.
तुम लोग को देखना नहीं है.
CIS system in the system. We can get. No, as a system officer. Okay, 7, 8 and 9. No, the main contention of the aggrieved party is that he has been not heard of.
Not only that,
Why?
not only,
Basic thing, because, yes,
for sake of argument, if at all opportunity are given is given. So whether the landed trial court can permit the unauthorized occupant to make.
No, that is not the concern of this court. That is not at all the concern of this court.
very limited jurisdiction.
Whether he is in unauthorizedly occupying or authorizedly occupying, he is occupying.
By the landed
Yes,
That will be decided. The fact is that he is occupying. The defendant or defendants is or are occupying.
suit for eviction. I am occupying, then only suit for
Occupying.
eviction.
So repair is to be done. Repair is to be made. So as regards to authorized, unauthorized, that contention is not our concern. Our concern is whether that this impugned application through which this impugned order has been passed, whether it has been passed after giving you an opportunity or not.
trial.
That is the main concern. No. First of all, kindly be kind enough to place the fact.
Yes.
Without placing the fact, you are placing the judgment. How can
That is-
how can a judgment corroborate without having the fact?
It states that if the lease period
Learned
is
counsel,
expired.
learned counsel, I
After
am
expiry of
unable to,
Let me complete my sentence.
no.
After the
I
expiry of
have
lease
got it.
period,
I have got it.
they don't
Once
have the
again,
right.
once again, you are going into that scenario that he is occupying unauthorized. He
Yes.
is under unauthorized occupancy.
Yes.
This court is not at all concerned with that. This court has a limited ambit to see whether the impugned order has been passed in accordance with law or not beyond that.
I'm not- I
Can you
want
produce those orders, order number 7, 8 and 9?
Right now.
Those are uploaded.
दे भाई. 7, 8 and 9 हो जाओ।
7, 8 ना?
हाँ, वो भी नहीं दिख रहा ना। वो शायद
Those will be there. Those are uploaded.
एक मिनट।
This 6.
Order number 7 says an application today is fixed for filing receipt of payment of cost and requisite. Both parties have filed their respective hajra. An application has been filed by the defendant praying for issuance of writ upon the local inspection commissioner. The petition has been filed along with requisites and receipt of fees of learned commissioner. Heard the learned counsel, as the commissioner fees has already been paid to the learned inspection commissioner, Shri Pradesia Munda advocate, hence the prayer for issuance of writ is considered and allowed. Let the writ be issued upon the learned inspection commissioner, Pradesia Munda advocate, for holding local inspection over the suit property as per the points mentioned in the petition.
So, as per order number 7, writ has been issued.
Writ has been issued. Now 8. 8 number.
Lord Counsel, do you have any objection as
No.
regards to these
No.
orders?
No. 8 और 9 दोनों होगा। तो फिर से अपन ये प्रॉब्लम कर रहा है इसलिए अपलोड नहीं हुआ चाहिए।
5, 6, 7.
8 and 9 is not available.
Whatever.
There was some problem in the server during last
Exactly.
1 or 2 months. Possibly due to that reason, it might have been for commissioner's report, submission of commissioner's report. 8 and 9.
Can any help be provided tomorrow?
Yes.
How can it be?
I will just get it now. I will ask my junior to note it down. I will inform the other side. If he agrees, then we can.
Then,
Yes.
tomorrow.
Tomorrow. देख लेना ना दोनों ऑर्डर पे 8 and 9 में क्या ऑर्डर हुआ।
And Learned Counsel, in the meantime, during the course of this day, you also go through.
Yes.
But we have to be confined within that application and the impugned order, not beyond that. This court is not at all concerned with the whether he is in unauthorized occupation or not.
Because
That
that is
is
a
to
matter
be-
of trial.
That is to be decided.
Because on that point, that the judgment says that if the lease period is expired and it has not been extended for further period, the lessee doesn't have any right to get any benefit or any interim.
That cannot be so.
Yes, I am having the judgment. of the honorable
You will show that.
I will produce.
Let him give the citation so that I will be come
I am
prepared.
giving a copy of the judgment, no problem.
Thank you very much. Okay.
Let me also provide the citation.
And relying upon page number 5, last paragraph.
AIR 1958, Supreme Court 789.
Just make a prediction.
Net connection.
I don't think, Your Lordship, anywhere it is written like that. This
No, no,
judgment
no.
is not at all
No.
on that.
We'll proceed with the hearing today. Learned counsel,
My lord,
you place the relevant
yes.
portion.
Yes.
page number 5, last paragraph. Page number is given in the bottom.
Hmm,
I'm reading that paragraph.
hmm.
We have not been able to find in the laws or customs of this country any traces of the existence of all absolute rule of law that whatever is affixed or built on this soil becomes a part of it and is subjected to the same rights of property as the soil itself. In the case of Vallabh Das Naranji versus Development Officer, Bandra, the Privy Council once again referred to Sir Barnes Peacock's observation as stated above. The Privy Council also quoted the following observation of Chief Justice in the case of Narayan versus Bolagi. We cannot, however, apply to cases arising in India the doctrine of the English law as to buildings, that they should belong to the owner of the land. The only doctrine which we can apply in the doctrine established in India that the party to building on another land should be allowed to remove the material. Normally, under section 108 of the Transfer of Property Act, before the expiry of the lease, a lessee can remove all structure and buildings erected by him on the demised land. All that was necessary for him to do was to give back the land to the lessor on the termination of the lease in the same condition as he found it. The ownership, therefore, of the building in this case was not with the lessor but was with the lessee. Under section 108 of the Transfer Property Act, there was nothing to prevent the lessee contracting to hand over any building or structure erected on the land by them to the lessor without receiving any compensation. In other words, although section 108, the lessee had the right to remove the building by contract, they had agreed to hand over the same to the lessor without the right of receive compensation at the end. Such and such. Now, when we come to page number 7, second, third, fourth paragraph. From the top, fourth paragraph, page number 7. I'm ready. It was next asked that even if there had been no drainage of the building to be erected on the land, possession of it could not be given to the applicant until the lease had been determined, which in law could not be determined so long as the respondent could not be evicted from the demised land of which they were tenants within the meaning of the act. This contention is without force, as the provision of the act do not provide for the continuation of a lease beyond the specified period stated therein. All that the act does is to give to the person who continues to remain in possession of the land, although the period of lease had come to an end, the status of a statutory tenant. That is to say, although the lease had come to an end, but the lessee continued to remain in possession without due consent of the lessor, he would nonetheless be a tenant of the land and could not be evicted save as provided by the act. Now, last, then the page number 8, last paragraph, the conclusive part. Page number 8, last paragraph, conclusive part of the judgment. The appeal accordingly is allowed with cost throughout, and the decision of the High Court in appeal is set aside. The appellants are entitled to a declaration that the building constructed on the land demands under the lease exhibited belong to the Mankeshwar Temple Trust, the lessor, and the aid trust is entitled to recover all the rents and profits from the same, and the respondent have no right, title, and interest therein since the expiry of this said lease. So here the same case, lease period has been expired in the year 2021. They are in unauthorized occupation, they don't have any right.
In your authority cited by you in page number 7,
Yes.
in the second, third, fourth, fifth, sixth line, of paragraph number 4.
Correct.
Sixth line of paragraph number 4. All that the act does is to give to the person who continues to remain in possession of the land, although the period of the lease had come to an end, the status of a statutory tenant.
That is the observation by the Honorable High Court. And it was set aside by the Honorable Supreme Court in the last paragraph.
Wherein-
It was
Wherein your contention that which you were mentioning
last
is
paragraph.
stated.
last
That-
last paragraph of the judgment. The conclusive part of the
Hmm.
judgment is the last paragraph.
Hmm.
The appellants are entitled to a declaration that the building constructed on the land demarcated under the lease exhibited belong to the Mankeshwar Temple Trust, and the 8th Trust is entitled to recover all the rents and profits from the same, and the respondent have no right, title and interest therein since the expiration of the said lease.
Hmm.
The first respondent is directed to render an account of the rents received by him from the, that is email. So my submission is that after expiry of the lease period, the opposite parties herein were the lessee, they don't have any right over that. So my submission is that as because they don't have any right over the suit land, they are not entitled to get any interim relief. That's it. Expiry of the lease is admitted. Even though I have
Anything-
issued the notice for vacation or recovery of possession of the land, they given a reply. And it has been admitted in the reply that yes, the lease period has expired in the year 2021. So we are interested to continue the lease and come forward and enter into a fresh lease deal. So I have it. So it is admitted that the lease period has been.
Anything more to be submitted?
Your Lordship, my submission is that this stage, Your Lordship, the main thing is the perversity in the order of the Honorable Court.
Hmm.
Now, when the learned commissioner was appointed, basically there was party, whatever submission was required to be made, the defendant submitted about his application, the plaintiff raised formal objection, commissioner was appointed,
Hmm.
commissioner has given a report,
Hmm.
report clearly speaks about repair. And if your lordship might have noted it, all those things were like wooden things.
Hmm.
Wooden things have to be replaced. So these were the things which were required to be repaired.
Hmm.
If reconstruction is done, it's to be done, then flooring, slab, all these things are required. Pillars, raising of pillars, all these things would be there. It is not in that manner as has been submitted by the other side. So what is the perversity in the judgment order passed by the learned trial court that the other side is unable to project? Because relying upon the report of the commissioner, the trial court passed the order. And so far as interim relief is concerned, under Order 39 Rule 1, it clearly speaks, Your Lordship, relating to restraining somebody and making all or any kind of order for the purpose of protecting the property so that the property is not getting damaged, wasted. You know, just CPC. where in any suit is proved by affidavit or otherwise that any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit or wrongfully sold in execution of a decree, or the defendant threatens or intends to remove or dispose of his property with a view to his creditors, and the defendant threatens to dispose of it, then the court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing the wasting, damaging, alienation, sale, removal, or disposition of the property. Here, Your Lordship, the court has considered the premises is in a condition which is required to be repaired. I am in occupation of the premises. It is suit for eviction. So the point that I am in occupation of the premises is undisputed. And the judgment of the Honorable Supreme Court, Your Lordship, which has been relied upon by the other side, itself helps me, saying that till the order is passed relating to eviction, I am a tenant in respect of the premises in question. Now, I am not going deep into the issue relating to the expiry of the lease, Your Lordship, because that is a subject matter of trial. However, I would like to submit that there was a condition in the lease deed itself that what at the time of vacating the premises, it would be the duty of the landlord to make the payment of the construction. Whatever construction I have done, that payment has to be made. That has not been done by him.
In the lease deed, it is there that repairing is to be made by the lessee, subject to payment by the lessor.
No,
No,
it is not.
That is not about repair, I'm telling. It is that at the time of vacating, he was required to give me the entire cost of construction, which he has not given. That is clearly given in the lease. I'm not coming. That's why I'm not.
Lord Council, has that stage come?
No, Your Lordship.
So
that's why I'm saying.
Why are you submitting?
Just because he said about expiry, I'm saying about this thing. That is the only reply to that.
Need not.
Your Lordship. So my
We have to be
submission,
confined within this application and the
my
impugned order.
submission is that, Your Lordship, when the commissioner has submitted his report, this is very important, Your Lordship. When the commissioner had submitted his report, that order he has not challenged. He made me to deposit the money also before the learner for the commissioner. Commissioner was appointed and commissioner has given the report. The report remained unchallenged. At no point of time he filed any objection to the report.
Lord Council.
Now, the learned trial court has considered the report, found that as per the report, the repair is to be carried out. What is the illegality in the order that is to be projected? Because material irregularity and illegality, that is the only, it can be the subject matter of section revision. So I am submitting, Your Lordship, this application is to be dismissed. This is my
The
submission.
whole intention of the opposite party to repair the, because it is a resource, dilapidated condition. They repair the resource and
Not
restart
the
the sale.
there is no report.
My land for last 3 years, they are not paying anything. They are enjoying my property without any public.
For that,
Lord
he has a
Council,
remedy.
will this court go into that aspect?
No, at the time of.
So, in spite of that. So, tomorrow you produce those two orders, order number
7 and 8. 7, 8, 9.
7, 8, 9.
7 I we got it. 8, 9.
8 and 9.
So only for order, for report like that. We have got just only words. I will get that done tomorrow. Calcutta, HCN 165. Calcutta, HCN 165. Jaydev, Alay Joydev Prasad Gupta, Shakuntala Bhattacharya. Here, the Honorable High Court, relying upon the judgment of the Honorable Supreme Court, discussed the issue relating to repair. What has been argued by the other side, that it is not a repair, it's completely a reconstruction, renovation, that also has been looked into by the Honorable High Court.
You are referring to which paragraphs?
Yes. Yeah, okay. Your Lordship, kindly give me, Your Lordship, I'll just. अभी print out निकाल के लाऊं। Paragraph 7, Your Lordship. Paragraph 7, 10. Paragraph 7 and 10, Your Lordship.
7 and 10.
Yes. And the learned trial court, Your Lordship, rejected the application. The Honorable High Court allowed it, saying that if certain things are there on the field, if tenant is in occupation, then he is entitled to get it repaired. If it is completely destroyed, the matter would be different. That is what has been stated.
The only contention now remains after both of your submissions is that whether,
Opportunity of hearing.
yes,
It was even
Opportunity of
of both
hearing.
the orders it is mentioned.
opportunity of hearing has been given to the opposite party, plaintiff or not.
It
That
is,
is the
Your
main-
Lordship.
That is the main contention.
Yes, this order number 6
Hmm.
speaks about the appearance of the party
Hmm.
and his formal objection
Hmm.
when commissioner was appointed. Order number 10, he made his submission, his appearance is recorded. Then where is the question of further opportunity of hearing? Yes,
When
order
it was-
number 10 may be seen.
When it was mentioned that it was
Your
for
counsel-
order,
No,
but
sir.
then question of appearance is not.
No, I'm saying about create.
Order,
Yes.
Order. Order, not
It's seen.
Only hearing was. Produce those orders, intermittent orders, that is 7, 8 and 9.
7, 8 and 9. Yes. Hearing concluded करके वही वही. Yes, I'll do. दिखाओ जरा. 7, 8 and 9. 8 and 9. 6 8 and 9. 6 तो हम लोग कैसे है ना? 6 और 10 तो है.
The learned Learned counsel, those orders,
Go through the.
because as the certified copies won't be able to be produced, so on consent, is on consent of both sides, those will be taken into consideration.
Item 2, PO2.
It would be better to have a typed copy. Can it be typed copy?
Item 2, PO2 of.
But I'm for the petitioner plaintiff.
22, 1 and 2. Respondent.
Respondent number 1 and 2.
Yes.
How many respondents are there?
3 respondents, sir.
Much. Hmm. What is the content?
The first tribunal.
Hmm.
Two orders have been assailed, Lord. The first one is of the learned trial court, refusing the injunction order. Immediately after the page 205, you not find the trial court's order. I'm not paginated, it's been a certified copy. I'm not supposed to even touch it, so it has not been paginated. Immediately after page 205, I'm not to find the trial court order.
Order number 3 dated 3/12/2024.
Yes, ma'am, yes.
Hmm.
May I please?
Hmm.
Today is fixed for hearing in respect of petition under Order 39, Rule 1 and 2 of the CPC filed by the plaintiff. Plaintiff and defendant number 3 are present by filing Hazira. The gist of the plaintiff's case is that the plaintiff herein is occupying a portion of wooded premises over an area to the extent of land bearing survey number 58/1/P, measuring area to the extent of 100 square meter of total area 0.0562 hectares, classified as house site within village Haddo, Port Blair, Tehsils. Since for the last more than 4 decades, on the basis of oral purchase effected in between the late husband of plaintiff and erstwhile recorded tenant of the subject land, Brij Mohan Giri, the plaintiff is residing with her mentally retarded son, Joy Kumar. He is also residing in the said building. The land has now been unlawfully recorded in the name of G. Vivekananda Giri in the government records of right. Plaintiff, along with her late husband Lal Bahadur, was residing over the subject premises for dwelling purpose and were enjoying the essential amenities, electricity and water connection, etc. And the plaintiff regularly remitting necessary charges for essential amenities. The husband of plaintiff died on 3/5/2020.
1 minute, Mr. आगे report টা একবার দেখুন। Be seated. Kindly be
Milo,
seated.
madam. Milo.
Let us proceed.
Yeah. But the first page of the order, last paragraph, plaintiff along with her husband of Lal Bahadur was residing over the subject premises for dwelling purpose and were enjoying the essential amenities, electricity and water connection. And the plaintiff regularly remitting necessary charges for such essential amenities. The husband of plaintiff died on 3/5/2020. There is no other land or immobile property for the plaintiff in this island except the suit scheduled land, which is used exclusively for dwelling purpose, under which the plaintiff and her mentally retarded son is residing. Suit scheduled land over which the plaintiff is residing along with her mentally retarded son, Jay Kumar, is in habitable condition for dwelling house, is neither in a ruinous or under dangerous condition which warrants immediate vacation under any of the provisions of Andaman and Nicobar Islands Municipal Regulation 1994. To the utter surprise and dismay, the defendant number 1 herein handed over a copy of notice in the form of final order under reference number so and so, dated 9/1/2024, passed and issued by the Secretary Port Blair Municipal Council, Port Blair, to adjacent premises holder Srimati Sharli Sunil, wherefrom it has come to the knowledge that within a period of 2 weeks from the date of its issuance on 9/1/2024, the said defendants with our other officials, including concerned police officials, would throw plaintiff and her mentally retarded son from the suit scheduled land. Notice in the form of final order under reference number so-and-so dated 9/1/2024 passed by and issued by the Secretary Port Blair Municipal Council, being the defendant number 1, is not sustainable in the eye of law for the reason that before passing the notice in the form of final order under number so-and-so dated 9/1/2024 passed and issued by the Secretary Port Blair Municipal Council, Port Blair, and no notice of hearing was given to the plaintiff, as it is a plaintiff who has been adversely affected by the impugned notice oblique order. The plaintiff approached the Honorable High Court challenging the notice dated 9/1/2024 issued and passed by the defendant number 2, herein WPA number 48 of 2024, which came to be disposed of on 6 February 2024 when the Honorable Court, upon considering the report dated 2nd February 2024, was pleased to direct defendant number 2 herein to take decision in the matter, and the plaintiff herein was accorded liberty to take exception to such report dated 2/2004. During the pendency of the case, plaintiff was accorded with liberty by the Honorable High Court, wide order dated so-and-so, to carry out repairs of the premises in question, which plaintiff carried out. The plaintiff on 8/7/2024 submitted exception to the report before the defendants authorities, raising all legal grounds to discard such report by the defendant number 2 while taking decision in the matter as directed by the Honorable Court. Finally, the defendant number 2 herein, wide impugned number 3934 dated 7/10/2024 passed order directing the dismantling the dwelling house of the plaintiff herein, and on her failure to do so, it was directed to be implemented through their agency. Thereafter, the defendant number 2, upon the matter being relegated back, passed the impugned order, being order number 3934 dated 7/10/2024, whereby the defendant number 2 have informed the plaintiff that even after 7 days from the date of receipt of such order, and on failure on the part of plaintiff to dismantle and remove the single story dwelling house standing over the suit land, the defendant number 1 and 2 shall cause demolition. The plaintiff for the second time questioned the impugned order number 3934 dated 7/10/2024 passed by the defendant number 2 herein before the writ court in WP number so-and-so, which came to be disposed of on 12/11/2024, and the plaintiff was granted 15 days time to file suit. In effect, the order number 3934 dated 7/10/2024 was kept in abeyance. Plaintiff has prayed for temporary injunction restraining defendants from not giving effect to and oblige or further effect to the impugned order number 3934 dated 7/10/2024 passed by the defendant number 1 and 2 herein, including other defendant number 3 herein, from creating any interference to the peaceful possession of plaintiffs over the suit and every part thereof till disposal of the instant suit. Plaintiff has filed notice of Secretary Municipal Council dated 9/1/2024, order passed in WPA number 48 of 2024, inspection report of the executive engineer dated 2/2/2003. It should have been not 2023. Order of Secretary Municipal Council dated 7/10/2024. Order of the Honorable High Court passed in WPA number 6134/2024, etc. Defendant number 3 has duly contested the injunction application petition by filing written objection denying the allegation of the plaintiff. The specific case of the defendants is that the plaintiff is not occupying the premises for the last 4 decades. In fact, plaintiff was engaged by the father of the defendant number 3 sometimes in the year 2009 as a caretaker. She was not permitted to carry out any construction upon the suit premises. However, it was agreed between the parties that the plaintiff can stay in the premises along with her son and husband and need not to have paid any rent to the father of the defendant number 3. It was mutual understanding between the plaintiff and father of the defendant number 3 in the way that the plaintiff will take care of the premises and she will be permitted to stay there along with her son and husband without paying any rent. In fact, the rent was the effort of the plaintiff to take care of the suit premises. There is no building in the suit premises. In fact, it is a single-storied wooden structure which is presently in dilapidated condition. The house in question is completely dilapidated and dangerous for human dwelling. The defendant number 3 accordingly submitted an application before the PBMC for dismantling the said house. The PBMC conducted the proceeding. During the proceeding, the plaintiff participated. An order of dismantling the structure was passed on 9/1/2024. the plaintiff approached the Honorable High Court on the ground that the report of the executive engineer dated 3/22/2004 is incorrect and she should be given opportunity of hearing. The Honorable High Court granted opportunity to plaintiff. Thereafter, the case again proceeded and ultimately on 7/10/2024, the PBMC passed an order for removal/dismantling of the house in question. The approach of the plaintiff before the Honorable High Court thereafter did not yield any result. However, the plaintiff was given permission to file civil suit against the landlord to effect repair of the premises. The instant suit has been filed on 26/11/2024 after order of the Honorable High Court. Instead of seeking repair of the premises by mentioning her status as tenant, the plaintiff very cleverly set up the case for permanent injunction. The expert in the field has given a report and there is no material to ignore the report of the expert. It is incorrect that the secretary does not have the power to pass under Regulation 132 of Municipal Regulation 1994 and the power of the secretary cannot be challenged by the plaintiff. The property is in dangerous condition. The same has to be demolished. Otherwise, it will not only be dangerous for the plaintiff and her son, but also for the nearby residents. Safety of the general public has to be looked into and cannot be ignored. It is denied by the defendant number 3 that there is any connivance between the defendant number 3 and PBMC. Order is well-reasoned order and the same requires to be implemented. The defendants have prayed for reject plaintiff's temporary injunction petition. Peruse the case record along with documents filed by the plaintiff and consider the submission of both the parties. Plaintiff has only averred that the land was unlawfully recorded in the name of defendant number 3 in the government record of right, but has not mentioned whether he has filed any objection before the concerned authority against the unlawful recording. The notice of Secretary Municipal Council dated 9/1/2024 shows that the notice was served for dismantling under section 132 of Andaman and Nicobar Islands, against which WPA was filed, and the learned advocate for the present plaintiff, that is the petitioner of WPA, undertook that he would pay immediate steps for any repair and renovation work which would be safe for human habitation, and the direction was given by the Honorable High Court to the concerned authorities to conduct inspection on 2/2/2024 and they submit a report before the court. In pursuant to that order, inspection report was given by the executive engineer PBMC dated 2/2023, which transpires that the structure standing in the suitland in haphazard manner resembling a temporary arrangement and some of the wood and existing shed would visibly rotten and the structures was incapable to withstand cyclonic condition. Petitioner plaintiff again challenged the order and Honorable High Court directed the Municipal Council to take into consideration the report of executive engineer dated 2/2004 along with any material that may be filed by petitioner and to complete the entire exercise as expeditiously as possible within a period of 4 weeks in accordance with law. Again, order was passed by the Secretary Municipal Council dated 7/10/2024 for dismantling of the said structures, again which a writ petition was filed, but the Honorable High Court has observed that there is no perversity in that order and the Honorable Court did not interfere with the order of PBMC dated 7/10/2024, but liberty was given to the plaintiff to file civil suit against her landlord and the impugned order was stayed for a period of 15 days from 12/11/2024. Thereafter, plaintiff has filed the suit. Plaintiff has not challenged the order dated 7/10/2024 passed by the Secretary Municipal Council before its appellate forum. In this backdrop, I find there is no prima facie case to go for trial, and I do not find it to be prudent to grant any order of temporary injunction in this suit. Hence, it is ordered the prayer for plaintiff for temporary injunction under Order 39 Rule 1 and 2 CPC is hereby considered and rejected on contest. Now, I would just give the background because I have read the order of the trial court. Now, the admitted position is, which my adverse sides would not dispute, that I am occupying the suit premises. At the first instance, the Port Blair Municipal Council, my lord, under a Municipal Regulation 1994, which is prevailing in this island, issue a notice. Not in this island, if the council finds that any building is in a ruinous condition, then upon holding appropriate inquiry, dismantling and removal of structures can be ordered. In this case, that provision was invoked and that complaint was lodged by the defendant number 3 to the council, inviting the Port Blair Council to set an appropriate proceeding in motion and to pass an order. That first order in the form of a notice was challenged before a writ court. Only Port Blair Municipal Council was a party during the pendency of the writ petition, because it was strenuously argued by the counsel for the Port Blair Municipal Council in the first writ, that though the writ petition is residing, who is the plaintiff herein, but the structure is in a bad condition. The writ court allowed me to carry out repair. I carried out repair. Then, based on the writ court's order, the council was directed to hold an inspection to ascertain whether now the building is in perfect manner, whether I have carried out the repair or not. That was also done. Then that report was placed before the writ court. Then the writ court found that since report has come, the entire matter was relegated back to the Port Blair Municipal Council. Council was directed, now you take a decision. And I have been given liberty to take an exception to such report. When the matter was remanded back to the Port Blair Municipal Council, the writ petitioner, who being the plaintiff, took an exception. Lawful and recognized grounds were taken to question the report. For the second time, Port Blair Municipal Council again passes an order, same order, with few additional paragraphs recording the prayers. Even this time, invoking 132 of municipal regulation, again the dismantling of structures were directed. For the second time, again writ court was approached. Before the writ court, argument was very advanced. Ultimately, writ court said, since the list is a pure civil nature and dispute in terms of section 9 of CPC, you file a suit. You file a suit, the matter, entire thing needs to be thrashed out in a suit. Whether the repair can be done, whether it's in a habitable condition or not, whether the Port Blair Municipal Council were justified in their action in passing the dismantling order. Suit was filed. What would see, the suit was filed by my client before the trial court, seeking a decree of permanent injunction. I'll show that prayer. Even when prayer was made to allow plaintiff to effect repair, which would be considered at the appropriate stage. But this is the point. These are the catches. But pending disposal of the suit, I have took out an application under Order 39, Rule 1 and 2, seeking protection as regard my possession. Lord would have find in this island, there are big buildings, 10 stories. I'm residing in a small structures with my handicapped son, and the Port Blair Municipal Council is generous to others, but they are so keen that they want to dismantle my structure. Just because the reason is, the bottom line is, behind that, the defendant number 3 is there, who wants to get me evicted. Lord knows those judgment, one which cannot be done directly, should not be allowed to be done indirectly. The defendant number have chosen this course. He did not file any suit against me for eviction. He straight away approached the council, managed to get an order. These are the matter to be gone into in a trial. But just why I'm arguing this matter, just to bring to the notice that where the trial court went wrong. Now the second,
The respondent number 3 is the
person in whose name the suit line is recorded, is a recorded tenant, where I'm residing.
he is the recorded tenant.
My lord,
You are in which status you are?
I have purchased orally. My suit, I'll just show that I have annexed the plain. They say I'm a tenant. They say in the trial court, as I've been allowed to occupy the suit premises in the permissive capacity as a caretaker.
Purchased orally.
Orally. Oral.
Does the Transfer of Property Act does not lie herein?
Yes. 54 TP Act, Lord would see, it recognized only contract of sale. Contract can be orally or in terms of writing also. There are judgments I can place it. Oral contract is permissible.
More than 100 rupees property worth more than 100 rupees. Can it be contracted orally?
Here I'm not sure it can be done. I will show a registration act also.
Whether Transfer of Property Act
Applies here. Yes.
applicable here or not?
With full force. With full force. I would argue what has fallen from my lord, I'm bound to answer it, I will answer it. But these are the matter to be gone into in the suit. That's what I say. The limitation so far as civil division is very, very limited. The legality and propriety of the order needs to be seen. Whether there is any patent illegality. Because the trial court, one would see at page 8, again, just 2 lines I'll show, which I've read just now. The trial court said the first 3 lines. This is the only reasoning assigned by the trial court.
Yes.
Plaintiff has not challenged the order dated 7/10/2024 passed by the Secretary Municipal Council before its appellate forum. Lord would see preceding paragraphs are the submission being recorded. Now, Malad have to see what is this order dated 7/10/2024, where from this order came to be passed, whether that order is amenable to an appeal under the municipal regulation, that needs to be seen. If that is not there, the trial court went wrong. Let me throw Malad to the order dated 7/10/2024, which is in the form of a dismantling order under section 132 of municipal regulation. I'll show that. Just one second. Just one second. One second. Now it's at 177. My learner sister is kind enough to just refer to page 177. Being the maker of the petition, even I could not get hold of it. No, page 177. 177. It's an order number 3934 dated 7/10/2024. This contains 2 pages. I will place right from page 177. It's order number 3934 dated 7/10/2024. Whereas it has been reported to the undersigned that a complaint has been received from Sri G. Vivekananda Giri, that's OP number 3, residence of Hado, with the request to evict his occupant from his dilapidated and unsafe building, safely unfit for any form of human habitation, on plot bearing survey number 58/1/P, situated at Halo village. And whereas a notice number so-and-so dated 9/1/2024 under section 132 of Andaman and Nicobar Islands Municipal Regulation 1994 was issued.
Let Mr. Jaipal continue, I'll just come.
Yes.
Was issued to Sri Vivekananda Giri, Srimati Shirley Shuri and Ajay Kumari. Malad would find my name, do figured out. Tenants with direction to remove/dismantle the single-story semi-timber structures. And whereas the Honorable High Court at Calcutta Circuit Bench at Sri Vijayapuram passed an order dated 18/1/2024 in the matter of WPA number so-and-so, then it has been quoted, the authorities will conduct an inspection on 2/2/2024 and submit a report before this court as to whether there was any improvement since last inspection. And whereas the Honorable High Court at Calcutta Circuit Bench at Sri Vijayapuram passed an order dated 6/2/2024 in the matter of WPA number 48/2024, Ajay Kumari versus Andaman Nicobar Administration and others, that this court directs the Municipal Council to take into consideration the reports of Executive Engineer dated 2nd February 2024, along with any materials that may be filed by the petitioner contradicting such report, and after giving an opportunity of hearing to the petitioner, pass a reason order. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks in accordance with law, pending final decision of the Municipal Council. There shall be an order of stay of operation of notice dated 9th January 2024. With the above observation and direction, the writ petition stands disposed of. And whereas, as per the judgment passed by the Honorable High Court at Calcutta Circuit Bench at Sri Vijayapuram, a notice was issued to the petitioner Srimati Ajay Kumari, wide number so-and-so dated 15/5/2024 and so-and-so dated 15/5/2024 for filing any objection to the inspection report within a period of 15 days. And whereas Srimati Ajay Kumari has filed only written submission without any supporting documents on dated 8/7/2024. And whereas as per the verdict dated 6/2/2024 of the Honorable High Court, Circuit Bench at Sri Vijayapuram in WPA number so-and-so, and an opportunity of hearing being heard before the Secretary Port SVPMC on 5/9/2024, wherein Counsel Advocate Ajay on behalf of Sri Vivekananda Giri and Counsel Advocate Sri Manu on behalf of Srimati Ajay Kumari was present. And whereas Srimati Ajay Kumari, writ petitioner, failed to produce any documents to contradict the inspection report of the executive engineer dated 2/2/2024. And whereas the Counsel Advocate Ajay on behalf of the Vivekananda Giri stated that the order passed by the SVPMC under section 132 and the judgment passed by the High Court is satisfactory. And whereas the Counsel Advocate Sri Manu on behalf of Srimati Ajay Kumari stated that as per the order passed by the High Court regarding the structure to be unsafe, the tenant renovated the structure and they are residing over the said land peacefully for more than 50 years from their father era. Further, the Advocate Sri Manu also stated that as per the judgment passed by the Honorable High Court, necessary action may be initiated by SVPMC. Whereas the single-story semi-timber structure in question is found to be unsafe condition for human inhabitation, and Sri Vijayapuram Municipal Council has issued a notice under section 132 of Andaman and Nicobar Islands Municipal Regulation 1994 for removal of dismantle of said structure, which was not complied by the party concerned, and as such, I hereby further order that necessary action for implementation of the notice dated 9/1/2024 issued under section 132 of Andaman and Nicobar Islands Municipal Regulation 1994 has to be proceeded at the earliest by the executive engineer works in accordance with the provisions of Andaman and Nicobar Islands Municipal Regulation 1994. Whereas instant order has been passed by the undersigned in compliance to the order dated 6/2/2024 passed by the Honorable High Court, Circuit Bench at Sri Vijayapuram in WP number so-and-so, Ajay Kumari Nada, you are hereby directed to remove/dismantle the single-storied semi-timber structures within a period of 7 days from the date of receipt of this order, and failing which demolition order will be carried out by the Municipal Council at your risk. Now, these 2 pages order are one which has been passed by the Port Blair Municipal Council in purported exercise of regulation, Municipal Regulation 132. Malad needs to see that regulation. 132, Andaman and Nicobar Island Municipal Council Regulation. This is not the one, Malad. Regulation 1994. Malad, I'm handing over the book. Just one second. Well, I've just taken, because I am having the one book, I've took the pictures of these 2 these sections. 132. No. Or would see, I'm just placing 132. If in any municipal area, any building, wall, or structure, or anything affixed thereto, or any bank or tree is deemed by municipality to be in a ruinous state, or in any very dangerous, the municipality may, by notice, require the owner thereof forthwith either to remove the same or cause such repairs to be made to the building, wall, structures, bank as the municipality may consider necessary for public safety, and if the requirement of such public safety and if the requirement of such notice is not complied with, the municipality shall forthwith take at the expense of the owner any steps which it think fit necessary for the purpose of averting imminent danger. Not the order 1 which I've just read now is passed in consonance with this provision. Let's go with that situation, Lordship. There is an order passed. The trial court said, this order those 3 lines in the penultimate paragraph is an appealable order. My lord, for which my lord have to see the appeal provision. Now kindly turns to regulation 187. 187. Can this order be said to be an order which is amenable to an appeal? That's the sole reasoning assigned by the court below. Trial court, I'm sorry. Trial court. Regulation 187 may kindly be seen there.
Yes,
187. My lord would see appeals from orders, etc.
Hmm.
of municipality. 187. Any person aggrieved, small a, by refusal of a municipality under section 166 to sanction the erection or re-erection of a building, or by a notice from a municipality under section 168 requiring the alteration or demolition of building, may appeal within 30 days from the date of such notice or refusal to such officer as the administrator may appoint in this behalf, or failing such appointment to the deputy commissioner, but no such notice or refusal shall be liable to be called on in question otherwise than by such appeal. Look, 2 orders are amenable to appeal under regulation 187. Save and accept this provision, my lord, regulation 187. There is no other provision for appeal. And what are those 2 appeals? What are those 2 orders which are amenable to appeal? One is appeal against refusal of a municipality under section 166. My lord needs to go back again. Regulation 166. Because the order 1 which I have questioned before the suit is not an order under regulation 166. My lord, kindly see regulation 166. Well,
So 166 is as regards to sanction for erection or re-erection of the building.
absolutely.
And 168 is the alteration or demolition of a building.
Absolutely. Those 2 provisions deals with if a building is raised without sanction plan, if the building has raised in deviation to building plan, there has to be a building plan, then those 2 orders can be passed, and those 2 orders are only amenable to an appeal under regulation 187.
Let the regulation 166 be placed.
My lord, may I take
Sure.
again, that book because I thought most of the court would be having the book. I have brought one. I'll take the photographs Lordship, of that provision. I'll take photographs and I'll give back the book. Yeah,
We have it.
yes, I'm grateful. I'm grateful. Can it turns to 166?
The Andaman and Nicobar Islands Municipal Regulation 1994.
Yeah. Yes. 166.
Yes.
I'll just draw my loss to 166. No, it's page, Malad would find power refuse sanction building plan. No, can you see?
Powers refuse sanction
Building plan.
to building.
If I go with, yes, plan. The sanction to building.
Sanction to building.
Bill. So if I go with this caption, that means if I apply for sanction of building plan, if it is refused, then it becomes an appeal. But I'll read it. Within 1 month after receipt of notice required by power subsection 162, the municipality may refuse to refuse the building or may sanction it either absolutely or such modification as it think fit in respect of all or any of the matters specified in subsection 3 of that section, and that person erecting or re-erecting any such building shall comply with the sanction of municipality as granted in every particulars. Provided that if the municipality neglects or omits for 2 months after receipt of valid notice to make and deliver to the person who has given such notice an order of sanction or refusal in respect thereof, it shall be deemed to have sanctioned the proposed building. It's a deemed provision.
So, if within 2 months it is not
It's a deemed provision.
deemed to be sanctioned.
My point of argument, my lord, the order which one I have shown, which is a subject matter of suit, is not an order under regulation 166. If it is not an order under 166, if it has no color, if it has no flavor of 166 order, then appeal do not lie. Then the trial court went wrong, because the trial court says against this order dated September 2024, which is under an order regulation 132, appeal lies. There the trial court went wrong. It's a patent illegality, I would say, not. It's an absurd finding. Am I clear to my lord?
Yes.
That's my first point. Secondly,
So, what was the relief available?
to not suit, because High Court has also granted me a liberty to file the suit. I'll show that order also. His Lordship Honorable Justice Rajshekar Manta, in my writ petition, asked me to file a suit till such time this order was kept in abeyance. Then the suit was filed, because I'm in possession of the suit property, having a dwelling house. But so this the order one which I've shown, it's not an order under regulation 166. If it's not an order under regulation 187, which deals with an appeal provision, it's not amenable to an appeal. Now the second order is under order under section 168. My lord would find in the next page. Penalty for building without sanction. It is correlated with 166. If I raise a building without any plan, then what are the penalties which can be saddled? My lord would see, if the erection or re-erection of a building is begun or continued without sanction and without sanction as required by subsection 1 of section 162, or without notice as required by subsection 2 of section 162, or after sanction has been refused, or in contravention of terms of any sanction granted, or after the sanction has lapsed, any contravention of any bylaws made under section 163, the municipality may by notice to be delivered within a reasonable time require the building to be altered, demolished as it thinks necessary within a space of 30 days from the date of service of such notice. Even the order which I have shown, lordship, it has no flavor of regulation 168, because these two sections are mainly dealing with, lordship, that one who want to raise a building within municipality must obtain a plan. If it is not done, 168 would come into play. And any order passed is amenable to an appeal under regulation 187.
These two are in respect of positive erection of
Yes, yes.
building.
But so far as my order which I have challenged, it's under regulation 1, my lord would see 132, which I have read at the first instance. It's not an appealable order. If that be the case, the trial court went wrong. What I'm asking for, lordship, what was my prayer before the trial court? I'm in possession. I would effect repair. There's an prayer for effecting repairs, which I would press at the appropriate stage. Initial stage was not an appropriate stage, I would say, my lord. I'm simply seeking for a injunction, temporary injunction as regard my possession.
Anything more?
Lord, this is one. This order was carried in appeal. This order was carried because order being an order under order 39 rule 1 and 2, order 43 rule 1R is remedy available. I approached before the district judge, and the district judge passed the order, which my lord would find the next order after the trial court's order. It's an order of affirmation. So these two orders were challenged in the civil division. The first appellate court endorsed the trial court's finding. Before the first appellate court, a new point was argued by my adverse side. They say that the suit which I have filed against the Port Blair Municipal Council is not maintainable for want of notice under section 80 CPC. I have cited a judgment of the Supreme Court. Even I would cite that judgment even before this court. Insofar as a suit as against older municipalities are concerned, no notice under Section 80 is required. They are autonomous body, my lord. I'll show that judgment also. And I can read the first appellate court judgment also. It's an order of affirmation. The district judge said, my lord, that the honorable court, while granting me liberty, have clearly spelled out I have to file a suit against my landlord and I can seek for repair. But the district judge have missed the material on record. Already I'll show my plain, my lord. What is my plain case? What are prayers within its fold? I'll show that also.
Let the portion be placed.
My lord,
in the
my lord, of the district judge, my lord, page 6 of the judge, district judge order, page 6 on perusal at the bottom.
In the form of a judgment.
It's in the form of a judgment. Page 6 at the bottom. On perusal of the entire record and perusing the order passed in WPA number 613 of 2024, which was passed after filing second writ petition, clearly shows that the interim protection was given to the appellant to file a civil suit against her landlord to pursue the effect repair of premises, and the impugned order of municipality was stayed for 15 days from the dead date. But instead of making any prayer relating to repair, this appellant filed a civil suit for declaration of permanent injunction, etc., which was not the intention of the honorable court. If that be so, then the learned trial court has passed appropriate order rejecting the prayer for temporary injunction. I also find that no document has been produced before the municipal authority show that the inspection report is not true and it is not in a dilapidated condition where the appellant can reside. If that be so, then except prayer to allow repairing of the said premises, civil court cannot pass any order by passing the order of the Honorable High Court. Hence, the judgment cited from the side of the appellant is not applicable in this case. I do not find any ground to interfere with the order passed by the learned trial court. Appeal stands dismissed. Not the entire issue involved in the suit has been decided by the district judge, saying that this sort of prayer can't be made. No, kindly need to see the plain. No. I will just show two orders of the High Court, then plain.
Let us come back after.
My lord.
My two adverse side have not come yet.
They have given you a walkover.
Hey, madam will not give. Anjali madam will not give.
Her junior is there.
Can I start?
Yes.
No, I'll just show the plain. But it's page 44 is the prayer portion of the plaint.
Yes.
A decree of permanent injunction restraining each of the defendants from interfering with and disturbing actual physical possession of the plaintiff or the suit scheduled land. A decree declaring the impugned office order number 3934 dated 7/10/2024 passed by the defendant number N as null and void having issue. A decree declaring suit land fit for habitable purpose, temporary injunction. Then what would see Roman 5. Order allowing and obligor permitting plaintiff to make and carry out necessary repair and obligor renovation and obligor alteration and obligor addition to the suit property. So prayer has been made before the court that I am in possession, kindly grant me decree of permanent injunction. These are the matter into gone trial. Not sure what I have to show is a prima facie case. In a case of present nature, the prima facie case, an arguable case would be that I am in possession. Even if I am a squatter, even if I am an authorized occupant, I am in occupation. To evict me with due process of law. And in the present suit, liberty has been granted by a court, by a writ court, asking me to file a suit. I'll show that order also. So the district judge held that there is no prayer for repair. But already within its fold, there is a prayer for repair. And this I would press for at the appropriate stage. But the urgency was looming to obtain an ad interim injunction as regard my possession. Now kindly see that order of the Honorable Court, 2 orders, 2-3 papers, then I'll conclude my argument. Just one second. Look. The second order in the second writ is at page 179, Madam.
First one.
First one I'll show by Justice Hiranmay Bhattacharya. I'll just show that to you. The first order. Yes, Malad would find that order at page, I'm just placing it, 171, annexure P7. The petitioner has challenged the notice dated 9 January 2024 issued by the Secretary Port Blair Municipal Council directing petitioner to remove or dismantle single timber structure standing on plot number so and so at village. It appears from the said notice that it has been alleged that the building in question is rotten and in dilapidated condition and cannot withstand the natural calamities. Pursuant to an order dated January 18, 2024, the respondent has filed an affidavit annexing the copy of inspection report dated 2nd February 2024, wherein the date has been wrongly typed as 2nd January 2023. Upon going through the said inspection report, it appears that the executive engineer has opined that a structure is standing in a haphazard manner resembling a temporary arrangement by using aged and untreated wood. It has been further reported that the side walls exhibits a combination of old tin sheets and weatherhead wood panels, which was only then painted from the interior. Mr. Jaipal, an advocate appearing for the petitioner, challenges the said inspection report and submit that the building in question has been repaired and at present the same cannot be said to be in a ruinous state or in a dangerous state. Since the notice under section 132 has been issued and inspection pursuant to an order passed by this court has already been conducted, this court is of the considered view that the authority should be directed to consider as to whether the petitioner has complied with the requirement of such notice. The issue as to whether the building is in a ruinous or dangerous state requires an adjudication on facts. The petitioner should have also be given an opportunity to rely upon the materials to controvert the inspection report dated 2/2/2024. In view thereof, this court directs the municipal council to take into consideration the report of executive engineer dated 2nd January 2024, along with the material that may be filed by the petitioner contradicting such reports, and after giving an opportunity of hearing to the petitioner, pass a reasoned order. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks in accordance with law. Pending decision of the municipal council, there shall be an order of stay of operation of notice dated 9 January 2024. With these terms, Manoj, the matter was relegated back. Even Manoj would find this order dated, notice dated 9 January 2024. It's a replica of the second order, but it carries a caption as a notice, but it contains the same thing. I can show that order also. Manoj, just 9 January 2024. Manoj would find at page 169. 169. It's under section, not to say it carries a caption as notice, but not to say under section 132 of Andaman and Nicobar Islands Municipal Regulation 1994. It has been reported to the undersigned that the single-storied semi-timber structures belong to G. Vivekananda Giri, standing on plot survey number 58/1/P, situated at Hallow Village, is rotten and in dilapidated condition and cannot withstand natural calamities. Thus, the above structures may be removed and dismantled immediately under section 1632 of Andaman and Nicobar Island Municipal Regulation 1994, keeping in view the safety of the general public. So this notice was challenged at page 170. The order which I've read just now, disposed of by His Lordship Honorable Justice Srinivas Bhattacharya. The matter was sent to the council. Then this council passes that order, which is at page 177. Page 177, it's 7/10/2024 order. And this order, which I've read a lot, was again challenged at page 179. Page 179. I'm just reading page 179. May I read page 179?
Yes.
It's order dated 12th November 2024 in the second read. Pursuant to an order of this court passed in WP number so and so, the Secretary Port Blair Municipal Council considered the inspection report dated 2/2/2024 and found that the building in question is dangerous to live in. The petitioner claims that since after receiving the notice from the PBMC, she has effected the repairs. The executive engineer as well as the Secretary Port Blair Municipal Council have reported that the repairs are a lip service and not effective service. In those circumstances, since the impugn order has been passed by the Secretary Municipal PBMC after complying with the principle of natural justice and there is no perversity herein, this court is not inclined to interfere with the order of the Secretary PBMC dated 7/10/2024. The petitioner may seek remedy available under law in respect of his grievance. So liberty has been granted. Then court adds further at page 180, Mr. Jaipal Learned Counsel for the petitioner seeks interim protection till such time so that she would be able to file civil suit against her landlord to pursue the effect of repair of the premises. The impugn order shall not to be implemented for a period of 15 days from the date the writ petition was disposed of. Then the suit came to be filed challenging this order. That's the order dated 7/10/2024. I have been given my right to challenge the order dated 7/10/2024 has been kept open. I have been given liberty to challenge it in accordance with law. You file a suit. Along with that, you seek for repair. Nowhere, my lord, any of the court have precluded me not to get an injunction order because I'm in possession. I'm in possession of the suit property. I have a right to protect my possession, my lordship. Suit would take its logical conclusion, my lord. Repair would be effected at the appropriate stage after obtaining the order of a civil court. Then, my lordship, I have shown at the first instance the order of the trial court, district judge order. Now I am before this court. Now, these are the materials. My lord would show the other papers, electricity bills, medical documents showing that my handicapped son is residing. No, I just fail to understand one thing. Leaving aside these papers, my lord, in entire Port Blair, only this is small structure dwelling house where I'm residing is pricking the eyes of Port Blair Municipal Council. The reason behind is the opposite party number 3. Because he want to, by hook and crook, want to evict me. He have not filed a suit. This act of council is malafide, I would say. There is a clear-cut case of hand in gloves. Connivance Act. The fact remains, prima facie, I have a good case to go for trial. Whether I would get a decree or not, that the trial court would decide. But for the present moment, what I have to show, I am in possession. And I've challenged that order of dismantling. 7/10/2024 order is under challenge. Inspection report based on which that order was passed is challenged before a civil court. I have sought for temporary injunction. I will go for a repair also. If the situation so demands in future. This aspect of the matter was missed by both trial court as well as the first appellate court. Kindly protect my possession. The suit can be expedited. Day-to-day hearing can be made, Lordship. Even if a suit is of fresh one, it can be done. But I pray, Lordship, these two orders has to be set aside. My temporary injunction prayer needs to be allowed, Lordship. Insofar as my possession is concerned, they are owner, they would remain owner. That's not a problem, Lordship. But so far as my suit is concerned, if it is not granted, Lordship, they would disturb my possession, they would interfere with my possession, Lord. Lord, just one judgment to the point. We'll just place that judgment. Reflected, I'm just placing that judgment, it's 2016 volume 2 SEC 200, the copy.
2016,
Volume 2 Supreme Court cases 200. To the point, to the proposition of law that if a suit is instituted against the Port Blair municipalities, there is no requirement of compliance of ATCPC because they are autonomous body. I'm just placing the hard copy of it, Lordship. It's retained in some lower court file. I'm just placing it, Lordship. Before my adverse sides complete their argument, I will place those judgments.
those means,
Not
those judgment means?
the only one.
Only one.
The only one. I have used the wrong term, Lordship. Only one judgment. That's the only one judgment.
2016 to SCC, page 200.
Yes, my lord. In few seconds, I'll place that judgment. That's all. I'm just placing the judgment in few seconds. Before they complete their argument, I will.
What is respondent number 3?
I'll start. Your Lordship, first of all, we have to see that what is the order under challenge? That is, in the civil suit, what order he has challenged. That is very important, Your Lordship. The plaintiff, Your Lordship, says apart from permanent injunction prayer, there is a prayer for declaring the impugned notice order 7/10/2024 passed by defendant number 1, 2 as null and void. This is the main prayer. Because on the basis of this particular order only, the building or the structure is going to be demolished. Am I right, Your Lordship? Now, Your Lordship, kindly see the order passed by Justice Rajshekhar Manta. Your Lordship. That is very important. Your Lordship, because I will be harping upon the point that a person who does not come to the court with clean hands is not entitled to get any kind of injunction. Here, Your Lordship, the petitioner taken a chance before the Honorable High Court and challenged the order, that order which is now the subject matter of the suit 7/10/2024 order before the Honorable High Court. Got it, Your Lordship? Now, what does the Honorable High Court has said? This is important. Kindly come to this paragraph. Pursuant to an order of this Honorable Court, passed in WP number, the Secretary Portable Municipal Council considered the inspection report dated 2/2/2024 and found that a building in question is dangerous to live in. The petitioner claimed that since after receiving the notice from PBMC, she has effected the repairs. The executive engineer as well as the Secretary PBMC have reported that the repairs are a lip service and not effective repairs. In those circumstances, since the impugned order has been passed by Secretary PBMC after complying with the principles of natural justice, there is no perversity therein. This court is not inclined to interfere with the order of the Secretary PBMC. When the Honorable High Court has already come to a definite conclusion that this particular order is not to be interfered with, unless and until this order is challenged and this part of the order is modified, taking it away from this particular order and making it a subject matter of the civil suit, whether we can ignore that order of 7/10/2024. That has reached its finality. 7/10/2024 order has reached its finality. We cannot touch that order because that order has already been affirmed by this Honorable Court. If we are touching the order, that means we are interfering with this order, which can be done only by the Honorable Division Bench. Because this court is not exercising any review jurisdiction. Now, the petitioner may seek remedies available under the law in respect of his grievances. Now, Mr. Jaipal, learned counsel for the writ petitioner, seeks interim protection till such time so that he would be able to file a civil suit against her landlord to pursue to effect repair of the premises. This is also very important. Court has granted him liberty, not liberty exactly. Court has granted, means considered granting him 15 days time so that he can file a civil suit against his landlord, asking him to repair the premises. Am I clear, Your Lordship? Now, what suit he has filed? He has filed a suit where he has contended that he is the purchaser of the property. The petitioner is submitting one thing before the Honorable High Court and thereafter going before the civil court and making another case. Whether such type of petitioner can be protected by this Honorable Court. He has not made any prayer for repair.
Wherein the plaintiff has sought for enforcing the oral or any agreement, to which prayer?
That is not there. That is not there. No case of specific performance.
Only for suit for permanent injunction.
Permanent injunction on the basis of an oral agreement, suit for permanent injunction. No relief has been claimed in respect of right title interest. Law is settled, Your Lordship, that if you are seeking as per section 34, 37 of the Specific Relief Act, it is very clear that you have to first claim the right. What is your right in respect of the land in question? No such prayer is there. The direct prayer is permanent injunction. On what basis? Oral agreement. Oral sale. Section 54 of the Transfer of Property Act 1882 is very clear with regard to sale. Section 17 of the Registration Act is also very clear about the sale. It is only by way of registered document and nothing else. I can understand that if he is possessing a registered sale deed, his name is recorded in the revenue records, even assuming for argument's sake, he is possessing a registered sale deed. then also the suit for permanent injunction would be maintainable because the title is not disputed. But here he doesn't have the title, he accepts me to be the owner. So the suit itself, Your Honor, basically it's not at all maintainable. In any circumstance, this argument can't be advanced here at this stage. However, what I am saying is, a person is approaching this honorable court. This honorable court is affirming the order of the municipal council. The Secretary Port Blair Municipal Council has ordered for demolition. He is challenging the order before the Honorable High Court. Honorable High Court has found that the order is absolutely correct. And thereafter, he is filing a civil suit, and now he is asking for a temporary injunction so that he should not be dispossessed. Your Honor, what cannot be obtained directly cannot be obtained indirectly also. This position is also clear, because unless and until she is removed from the premises, demolition cannot occur. The entire building is to be demolished, it's unsafe. So what he wanted, he doesn't want that the order should be stayed. He wanted that she should not be disposed, thereby meaning that the demolition cannot occur unless and until they are removed from the premises. How the demolition will occur? It's not a repair, it's not renovation, it's a demolition. And one main thing is that page number 57, Your Lordship, the prayer also may be seen. This is also very peculiar. Temporary injunction prayer.
Page
57. This is a prayer. Temporary injunction restraining defendant from not giving effect to or further effect to the order number this, dated this, passed by defendant number 1 and 2 herein, including defendant number 3 herein, from creating any interference to the peaceful possession of the plaintiff over the suit property and every part thereof. Now, this particular order he wanted to get a stay, which has been affirmed by the Honorable High Court. Can this order be stayed? You know, my submission is that, Your Honor, when an order has already reached finality, the other side cannot take advantage of any.
yes.
He has not been given any liberty by the Honorable High Court to challenge this order before the appropriate forum or before the civil court. Has not been given. Now he is challenging that order, wants stay of that order also. It is not that, one more thing, Your Lordship. It is not that the Honorable High Court said that this particular order cannot be interfered with because there is certain other provision, you can go to this court or that court. No, the Honorable High Court has adjudicated the importance and the correctness of this particular order on merits by considering the executive engineer's report and the order of the Port Blair Municipal Council. It was not a ground that the writ petition is not maintainable and therefore the writ petition cannot be sustained and the other side is given liberty. If that was the situation, I could have understand challenging of that order before the civil court and then asking for a remedy also.
So according to you, no liberty was granted.
No liberty was granted. To challenge this order, no liberty was granted. Whereas the Honorable High Court on merits affirmed the order. It was on merits. Now, the next thing is the inspection report. The inspection report,
And only granted that the impugned order shall not be implemented for a period of 15 days.
15 days. So that if he is able to get any remedy, if he is able to persuade the civil court or any other authority that still it is repairable and the landlord should be made to repair the premises, then the situation would have been different. But he has not sought for that. Though he has submitted before the Honorable High Court that he will be seeking a direction upon the landlord to repair the premises, he did not seek for that. He did not file any suit for that.
Let us once again go through the prayer portion of the plaint.
Yes. Page number 44. A decree of permanent injunction restraining each of the defendants from interfering with and disturbing actual physical possession of the plaintiff or the suit property. No prayer for repair. A decree declaring the office order number this dated this passed by the defendant number 2 as null and void. A decree declaring suit schedule land fit for habitable purpose. Temporary injunction. Now this is temporary injunction. Next, last one is there. Order allowing or permitting the plaintiff to make out, carry out necessary repair or renovation or alteration addition to the suit property. This is the last one. But what was the order? What was the submission before the Honorable High Court? That he will be seeking a direction upon the landlord for repair of the premises. This is something else. This is the one where he wanted to repair the premises on his own, which was already granted to him earlier. The first round of litigation, your lordship would remember that he was permitted to carry out some repairs.
Yes.
Your Honor, page number 170.
170.
170. Now here, this is in the first round of litigation, when the petitioner approached this honorable court, what the petitioner has sought. Mr. Jayapal, learned advocate appearing for the petitioner, undertakes that he would take immediate steps for any repair and renovation work which would be safe for human habitation and is the main complaint of the Secretary PVMC. The authorities will conduct an inspection on 2/2/2024 and submit a report before this honorable court as to whether there has been any improvement since the last inspection. So an opportunity to repair and renovate the building was granted to him. Now kindly come to the inspection report.
Where's the inspection
Yes.
report?
This is a 174. The date is by mistake. It is 2023. It is written 2024. No dispute to that fact. In compliance with the writ petition, WPA number Ajay Kumari was the versus the Andaman and Nicobar administration and others. And in accordance with the honorable directive on 2/2/2024, a thorough inspection of the site has been conducted. The purpose was to provide a detailed report for onward submission before the honorable court. Upon detailed inspection of junior engineer planning, SSL engineer planning, and further inspection of site by the undersigned on 2/2/2024, it has been observed that the structure in question has undergone some modifications, including a fresh coat of paint and the installation of new tin roofing sheets. However, a critical concern arises from the fact that these new sheets are supported by deteriorating old wooden purlins. The structural integrity of these purlins is compromised, contributing to overall instability of the building. The current state of the structure indicates that it is standing in a haphazard manner, resembling a temporary arrangement. The use of aged and untreated wood from the existing shed, some of which is visibly rotten and unpainted, raises significant safety issues. Notably, the side walls exhibit a combination of old tin sheets and weathered wooden panels, the latter being painted only from the interior. An alarming finding is that under severe cyclonic conditions, the building on site is deemed incapable of withstanding such weather events. This poses an imminent threat to the lives of the residents as well as the risk of substantial property damage. This report. Now, this particular report, this is very important, Your Lordship, has not been challenged. Has not been challenged before the civil court. They filed an exception to the inspection report, raising unnecessary pleas without any support of any expert. And then order was passed on 7/10/2024 by the Port Blair Municipal Council. Your Lordship, when an engineer gives an inspection report, it's like an expert report. And unless and until somebody is very well versed in that particular field, we can, even if we are going and inspecting the property, we cannot give a report of this kind. It's not possible. Expert report can be curtailed by another expert report only. There is no such expert report submitted by the petitioner at any point of time. And this has reached its finality because 7/10/2024 order, when the Honorable High Court has affirmed that order, the Honorable High Court has considered the report of the Commissioner also. At that relevant point of time, the 2nd February 2024 report was there before the Honorable Court. And the Honorable High Court has observed in the order that, I'm just placing it again, the executive engineer as well as the Secretary PBMC have reported that the repairs are lip service and not effective repairs. Means all these things were considered and order was passed. Now, sympathetic ground, Your Lordship, cannot be taken in order to brush aside all the relevant facts. These are the relevant facts of the case where a person is staying in a dilapidated conditional house, where already the expert opinion is there, expert report is there, order is there. Despite such fact, they are filing a civil suit just with an intention to stall the entire thing. Is whether it should be allowed. And making submission before the Honorable Court something and going to the civil court for something else. Designating me as a landlord at one point of time and another point of time as a seller. So this is a clear case, Your Lordship, where no interim order should be granted to the petitioner. He has not come before this Honorable Court, before the civil court, and also before the earlier court with clean hands. Your Lordship, I am relying upon a judgment. Your Lordship, I am relying upon the judgment of the Honorable Supreme Court. Reported in 1994, Supply 2, SCC 369.
SCC.
Yes, I will be giving the photocopy.
This is supplementary.
Yes, supply 2,
Yes. Refer, one second, refer to the citation.
1994, supply 2, SCC,
1994, supply 2.
SCC 369.
Amarnath Suganchad
Yes,
versus Lalchand Bansal.
yes.
Hmm.
Here, Your Lordship, the Honorable Supreme Court has held that it was a dispute between the landlord and tenant. Though he is not designating himself as a tenant, however, he is an occupier. Let us take as an occupier. Even as an occupier, if an appropriate authority has come to a definite conclusion that the building is unsafe, whether the Honorable Court can exercise any jurisdiction to say that it can be repaired, that was the issue. Now, I am coming paragraph 9, paragraph 8. In the instant case, both the appellate authority as well as the High Court have on proper consideration and appraisal of the evidence adduced by, besides others, an engineer draftsman reports submitted by commissioners appointed by them respectively have come to a conclusion that the premises tenanted to the appellants was unsafe and unfit for human habitation. I am stalling for a moment, Your Lordship, just to show that the inspection report has not been challenged by him in the civil court. Now we have in our hand a report which is in the final form. Hence, we will not be justified in disturbing the said finding in absence of any material to substantiate the concern. This coming now to the premises occupied by the respondent. We find that after considering in detail the evidence, both rent control and appellate authority recorded a finding that the premises were unfit and unsafe for human habitation. Now here, Your Lordship, the position would be of municipal secretary. Municipal secretary has come to a definite conclusion after hearing both the parties, after considering the inspection report that the building is unsafe. And that order was affirmed by the Honorable High Court. Same position, Your Lordship. There it was rent control and appellate authority. Here it is the Port Blair Municipal Council and the Honorable High Court. In such circumstances, the High Court was not justified while sitting in revision to upset the same. Incidentally, it may be mentioned that commissioner appointed by the High Court was asked only to ascertain the nature and condition of the premises occupied by the appellants, and indeed the High Court was asked the commissioner to only ascertain so far as the premises occupied by the respondent was concerned. So, Your Lordship, that is incidental. So the Honorable High Court has come to a definite conclusion that once when a proper adjudication has been done, considering the inspection so carried out by the appropriate authority, and a finding and a decision has been arrived at by the authority concerned, which has been affirmed by the appellate authority or the superior authority, here in this case, to my opinion, Port Blair Municipal Council has taken a decision which has been affirmed by the Honorable High Court. Now, whether that particular thing can be upset by way of a temporary injunction, this is the judgment.
Anything more?
Yes, Your Lordship. Your Lordship,
Hmm.
Regulation 194. Your Lordship may kindly come to Regulation 194. Port Blair Municipal Council, Your Lordship, Regulation.
Hmm. 194.
Yes. Regulation 190.
Yes.
Your Lordship, it may be true that so far as Section 80 is concerned, no notice is required. But what about this 194? Can be connected with Section 80. No suits shall be instituted against the municipality or against any member, officer, or servant of a municipality in respect of any act purporting to be done in its or his official capacity until the expiration of 1 month next after notice in writing has been in the case of a municipality delivered or left at its office, and in the case of an officer or servant delivered to him or left at his office or place of abode, stating the cause of action and the name and place of abode of the intending plaintiff. This is there in the regulation itself. For an autonomous body, Section 80, I can understand, Your Lordship, there is a judgment of the Honorable Supreme Court on it also. But whether in the regulation, if that is the stipulation, can it be done? Now, only one provision is proviso is there, provided that nothing in this section applied to any suit instituted under Section 54 of the Specific Relief Act 1877. That is for perpetual injunction, not permanent injunction. Both are different. Section 54 of 1877 that relates to perpetual injunction. So this notice has also not been issued. The counsel for the petitioner has submitted that the trial court, first court, Your Lordship, has not just rejected the temporary injunction petition on the ground that appeal provision is there and nothing else. But Your Lordship, if Your Lordship would go through the order of the trial court as well as the appellate court, other discussions are also there. It's not the point of only appeal. There are many other things. Inner page 6 of the
Page number?
page number, pagination is not there, Your Lordship, because it's a certified copy. Inner page 6.
Yes. 600.
Last paragraph, it starts from plaintiff has only averred. Plaintiff has only averred the land was unlawfully recorded in the name of defendant number 3 in the government ROR, but has not mentioned that whether he has filed any objection before the concerned authority against the unlawful recording. The notice of Secretary Port Blair Municipal Council dated 9/1/2024 shows that notice was served for dismantling under Section 132 of Andaman and Nicobar Islands, against which WPA was filed, and learned advocate for the present plaintiff, that is a petitioner of WPA, undertook that he would pay immediate step for any repair and renovation work, which would be safe for human habitation, and direction was given by the Honorable High Court to concerned authorities to conduct inspection on this and submit a report before the court. In pursuant of that order, inspection report was given by the executive engineer PBMC dated 2/2/2023, which transpires that a structure standing in the suitland in a haphazard manner, resembling a temporary arrangement, and some of the wood and existing shade would visibly rotten, and the structure was incapable to withstand cyclonic condition. Petitioner plaintiff against challenged the order, and Honorable Court directed the Municipal Council to take into consideration the report of executive engineer dated this, along with any material that may be filed by the petitioner, and to complete the entire exercise as expeditiously as possible within a period of 4 weeks in accordance with law. Again, order was passed by the Secretary Portable Municipal Council dated this for dismantling the structure, against which a writ was filed, but the Honorable High Court has observed that there is no perversity in that order, and the Honorable Court did not interfere with the order of this, but liberty was given to file a civil suit against her landlord, and the impugned order was stayed for a period of 15 days. Thereafter, the plaintiff has filed its state. Plaintiff has not challenged the order of this passed by before its appellate forum in this background. So all these things were taken into consideration by the court, because that particular order of 7/10/2024 was affirmed by the Honorable High Court, has been considered by the Learned Trial Court. And thereafter, Your Lordship, the order was passed. Now, the appellate court. Appellate court also, Your Lordship, considered the order of the Honorable High Court, because both the courts are bound by the order of the Honorable High Court, Your Lordship. They cannot travel beyond that. Even the appellate court also considered that aspect. On perusal of entire record and perusing the order passed in WPA 613 of 2024, which was passed after filing second writ petition, clearly shows that interim protection was given to appellant to file a civil suit against her landlord.
Which portion you are furnishing?
Yes, Your Lordship. Inner page 6 of the appellate court's order.
Yes.
On perusal, last paragraph.
Yes.
Entire record and perusing the order passed in WPA this, which was passed after filing second writ petition, clearly shows that interim protection was given to appellant to file a civil suit against her landlord to pursue to effect repair of the premises, and the impugned order of municipal authority was stayed for 15 days from the date. But instead of making any prayer relating to repair, this appellant filed a civil suit for declaration, permanent injunction, etc., which was not the intention of the Honorable Court. If that be so, then Learned Trial Court has passed the appropriate order rejecting the prayer of temporary injunction. I also find that no document has been produced before Portland Municipal Council to show that the inspection report is not true and it is not in dilapidated condition where appellant can reside. If that be so, then except prayer to allow repair of the Supreme Civil Court cannot pass any order bypassing the order of the Honorable Court. Kindly note, Your Lordship, the appellate court has looked into the fact relating to the question of repair, and the court has come to the conclusion that 7/10/2024 order has reached its finality. Once it has reached its finality, how all these courts can touch that order? Hence, the judgment cited by the appellant is not applicable, and I do not find it. So, Your Lordship, my submission is that the petitioner did not comply with the regulation. The petitioner did not come with clean hands before this Honorable Court. The petitioner has challenged the order before the civil court, which has reached its finality, affirmed by the Honorable High Court, and petitioner has not been able to produce any kind of document to show that the inspection report is vague or it is incorrect. So my submission is that, Your Lordship, the application may be dismissed.
Lord, I am appearing for 1 and 2, Portland Municipal Council. Lord, I will not trouble the factual aspect as well as the other side has already pointed out. Lord, the under 132, it is an independent section, my lord, under the regulation, municipal regulation, because if any building is found or it is brought to the knowledge of the authorities that certain building or certain structure in question has been found to be in unsafe and undilapidated conditions, that has to be removed. For the reason of this section is that, my lord, because if a building is found to be in unsafe, if it collapses, the persons who are residing or if any death has been caused due to that building, ultimately the liability will be foisted upon the council, saying that no action has been taken by the council. Not the private respondent here made a complaint saying that the building is in a dilapidated condition. The engineers, the building officials inspected the premises. They found that the building is in unsafe condition. It is constructed a wooden based structure. It is quite old building in question. We have issued a notice under 132. As we found the tenant is also there, we have issued notice to the tenant as well as the landlord. The writ petitioner, the tenant has approached before this honorable court, filed writ petition challenging the 132 notice. The honorable court, while deciding the first writ, granted liberty, or rather I could say granted opportunity to the petitioner to do repair. And further directed the PBMC building officials to conduct an inspection and submit a report before the honorable court with regard to the repair what has been done by the petitioner rather the plaintiff or as my lord before this honorable court. My lord, he has acted very smartly. What he has done, he has just coated paints and all. The walls, tin sheet walls, because I have produced the photographs also before the writ court. The honorable court, while deciding the first writ, as the report was submitted before the court, so they should get an opportunity to exception to the report, remitted the matter back to the Port Blair Municipal Council and granted opportunity to them also to file an exception to the report. They filed an exception. But if that being so, if the building in question is in good condition or it is in habitual condition, they could have produced some material, some documents to justify that stand. Merely filing an objection without supportive of any documents or evidence will not survive the purpose, my lord.
Anything more?
Yes, my lord. My lord, after that, we have passed an order in compliance to the Solomon order passed by this honorable court, and we have informed. See, you have not given any exception, rather, you could have not substantiated your stand. An order has been passed, the 132 notice have been affirmed. They rightly challenged it before the honorable writ court by filing a writ petition. Not both sides are produced. I have not troubled your lordship to read the judgment again. In the honorable writ court, as specifically it has been mentioned that the honorable court will not interfere with the order passed by the Port Blair Municipal Council. Subsequently, they say, my lord, we should get at least some liberty so that the premise in question can be repaired. Then the honorable court, it is specifically mentioned, but the honorable court does not interfere with the order passed with the Port Blair Municipal. Subsequently, they got a liberty to file a necessary suit for repair. And as per the rent control regulation, my lord, certain 28 is provided for filing a necessary application for repair, which they bypassed. They filed a suit challenging the same order which was affirmed by the Honorable High Court. And my lord, as prior C also, they say they himself admitting a decree declaring suit schedule land fit for habitual purpose. That means it is unhabitual purpose. That's why they want a decree should be made on this aspect. My lord, before this honorable court, we are hearing an order passed under identity under order 39 1 and 2. What is the prayer which is made in order 1 and 30, order 39 1 and 2? They say the order which was attained finality by the Honorable High Court has to be stayed. That is permissible, my lord. Kindly see the prayer, my lord. Order number 393, which is the order which is passed by the Port Blair Municipal Council under the second writ petition. Page number 57 is the injunction application, my lord.
You are referring to which page?
Page number 57, my lord. Para 1, temporary, para number 23, my lord. Temporary injunction restraining the defendant for not giving effect or to do and or further effect to the impugned order number 39 39 1 and 2. They say the order which was attained finality by the Honorable High Court has to be stayed. That is permissible, my lord. Kindly see the prayer, my lord. Order number 393, which is the order which is passed by the Port Blair Municipal Council under the second writ petition. Page number 57 is the injunction application, my lord. 3934 dated 17/10/2024 passed by the different number 1 and 2 herein, including the other different number 3 herein, from creating any interference to the peaceful position of the plaintiff over the suit and every part thereof till disposal of the instant suit. And pending disposal, the ad interim order of the injunction will be restrained from not giving any effect. But these are the two prayers. And with regard to the order number 3934, which was passed by the PBMC after the order passed by this honorable court, and is challenged by a way of writ petition, which attained finality, Honorable Justice Rajshekar Mantha specifically mentioned that order. If they have any remedy apart from this, they can do it. That's why the liberty was granted to file a repair application under the repair application has to be filed, not a civil suit challenging this incident order, which is attained this finality. Not the honorable single bench trial court as well as the honorable district court as rightly held. My lord, the if my lord, I just read the last paragraph of the honorable district court order, whereby the district court has said. From the bottom, my lord, I can read from the top, my lord. This is page number 7 of the honorable district court order. To peruse the effect of repair of premises, the impugned order of municipal authority was stayed for 15 days from the date. But instead of making any prayer relating to repair, this appellant filed a civil suit for declaration, permanent injunction, etc., which was not the intention of the honorable court. If that being so, then the learned trial court has passed an appropriate order rejecting the prior of time injunction. I also find that no document has been produced before the municipal authority show that the inspection report is not true and it is not in dilapidated condition where appellant can reside. Even this civil court also they are not produced. Even this appeal court as well as before lordship also they are not produced. If that being so, the prayer for allowing repair of the said civil court cannot pass any order for passing the order of the honorable court. Hence, the judgment cited from the side of appellant is not applicable in this case. I do not find any ground to interfere with the order as by the trial court. But in this same similar circumstance, several premises have been demolished, but subject to cost of the petitioners because it is found to be a threat to life, my lord. Because the building is found to be dilapidated, and if it is failed on, then ultimately the life of a person will be gone.
In one of my matters, your worship, even it was listed this time also. This honorable court, the tenant has sought for stay of the demolition order passed by the court because the building was unsafe. It was rejected and building has been demolished. So
Several cases it has been done, my lord.
in that case itself, your lordship can get the entire thing. Everything is written in that case, Sultan and Son. So it is not that,
Item number?
your lordship, it was just, I will give your lordship the details.
Nandagopal
Injunction was not-
Nandagopal.
Nandagopal.
It was implemented, my lord. The
Because
order was implemented.
demolition has taken.
Provide it to the court officer.
I will. for it.
But very quickly, I'll give reply on documents, very quickly, because sufficient time has been consumed by 3 of us, very quickly. But the provision has been shown by my adverse side to regulation 194. May not kindly have a look to regulation 194, municipal regulation 194, to canvass this argument that suit cannot be, pre-suit notice is a mandate. But kindly come to regulation 192.
Yes.
194 of the municipal regulation 1994, my lord, kindly consider it. The perspective in which this provision has been brought within the book, my lord, needs to be seen. My lord would see it's a pre-suit notice required, 1 month time is required. My lord, this substantive provision and exception is 54 of Old Act. The perpetual injunction is akin to permanent decree of permanent injunction. If that is claimed in a suit, then the substantive provision has no role to play. That's my point. So my argument would be suit is well maintained. And not this matter, these things need to be gone into in an appropriate stage. Issue would be framed whether suit is maintainable or not. Why at this juncture? My point is, my lord, a decree of permanent injunction falls within this exception being carved out to the proviso of this regulation 94. And even without issuing a notice, 1 month notice, I can maintain a suit. Not this 194 is akin to 80 CPC. Not this judgment may kindly be considered. It's 194 notice, pre-suit notice is akin to 80 CPC.
Yes.
Now I would see the judgment of the Supreme Court by Justice V. Gopala Gowda and Amitabha Roy. Well, I'll just refer to paragraph 26. Paragraph 26. Civil Procedure Code 1908 80 CPC, notice under not necessary when the suit is filed against municipal council, as the same is not a public officer, and no notice is necessary when a suit is filed against a municipality. So one can maintain a suit against the municipality without serving any notice, be it under section 80, be it under section 194. If this court holds that my case do not attract with the proviso clause. This is reply with on law points. Secondly, the judgment which my adverse side have shown of the apex courts of 1992, not their full dress trial was done. In that case, there was a full dress trial, full-fledged trial was conducted. But the present issue is on an interlocutory stage. The trial needs to be gone into. Then the court would come to a conclusion. Then, though in those matters, the entire thing was done, it traveled up to the apex court. So the judgment is distinguishable on facts. Now we are at the very initial stage of the suit. When I have sought for temporary injunction, that was turned down. Now, third, this is being argued by both sides by joining the hands. Lord, His Lordship Honorable Justice Rajshekhar Manta said that and rather not interfere with the order. Lord, when in a writ jurisdiction any order is challenged and the court do not interfere, that does not preclude a party to such proceeding to file a suit. Lord knows a declaratory relief even cannot be granted by the Supreme Court. One has to file a civil suit.
Your Lordship reply.
Law point I'm saying, it's on law point. I'm not saying law point.
These are not.
It's on law point. Of course it's a law point. Interpretation of the order. Of course it's a law point.
It's not a law.
And nowhere His Lordship said that I cannot maintain a suit. Rather leave has been granted.
Again,
That-
the fact of the matter.
No, sir, it's law point.
Like,
It's a law point I'm saying.
Please be seated.
That I've not been precluded in filing this suit. Rather leave has been granted. But kindly see the last paragraph of his order of Justice Rajshekhar Manta. Order was not interfered.
No.
My lord.
We have gone through,
My lord.
not once.
No, true. Interpretation, my lordship. What the other side is trying to project now is not the correct interpretation.
No.
Well, my saying is in a
We
very
apply only law point, nothing.
absolutely it's a law point. No, order showing of an high court.
Why are you going into the submission of the other side?
No, I am not going. I do not go and want their submission also, my lord. I want to persuade this honorable court that these orders cannot be sustained in the eye of law. In jurisdiction, it was not interfered, but it's civil nature of dispute. If I could show. These are all my submissions. My lordship, there is one more thing. If they want to propose to bring any additional material, because they have referred to one order of my lord which has been passed. These were never placed. There is some case laws they have shown, which my lord. No, that's what. If that is being relied, then I have a right to reply. This material was not either played before the trial court, first appellate court. Yes.
No issue.
Yes.
It was raised by the other side that no demolition earlier has taken place. For that reason only I wanted to show that. Not for any other purpose.
Those facts are different, Lord. Everything needs to be seen.
Exactly same fact.
The principal will always support the other side, Lord. They do so also.
Yes. Heard the learned counsel representing the petitioner at length, and the learned counsel representing the respondents number private, no. Respondent number 1, 2, and the respondent number 3. For orders, it be on 21st for orders.
Blair.
Obliged.
It was not,
Is the circuit is there up to 21?
Monday,
Yes, 20.
20th,
That's
not
right.
21st, 20th, Monday.
सर बताता फिर धीरे-धीरे.
बस सब ले जाके पास
As if second appeal was being heard. The earlier matter, it was being heard as if a second appeal has been.
No, they prompted me to argue. They prompted me.
Yes, next.
Item 3, CO3 of 2025.
And for the petition law.
You must let it be not to and do it tomorrow.
Such a lengthy one.
It's an injunction
Yes,
granted.
It
I'm
will
suffering
take time.
I'm
Yes,
suffering an
yes,
injunction
this one
order,
should
Lord.
take time.
in this case. It's Anila Soman case. I'm suffering an injunction
So
order.
several documents are there, it will take. Power of attorney, revocation of power of attorney, then again power of attorney. Many things are there. in it.
But may I say one thing, subject to what my lord says. Lord, let this application be taken up in the next circuit, but till such time the order needs to be stayed from its operation.
Okay, he will sell the property.
So now this has to be taken up during this circuit only. These are the way out. I've just proposed it. Already there is-
As regards to second appeal, that can be done, but as regards to civil revision, such a lengthy,
Next circuit.
No, 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 no.
Hearing also.
such a lengthy hearing.
No, but I have
It
an
will take
urgency.
time.
No, no. I will not take time, Lord. I would
What
take
is the urgency? He is restrained from selling the.
This can't be
What is
done.
urgency?
This can't be done. The clean
What is
hand,
the
what my
urgency?
adverse side is saying, she was not with the clean hand
No,
before the
I'm
court
not
below.
saying that about urgency, I'm saying.
Urgency is
3
there.
times I will prove.
Then the order may be stayed from its operation.
Why
Till,
it should be stayed? Why should?
then I have to argue. Then I have to
Sell the
argue.
property.
There is an urgency because every litigant
I
has an
am
urgency.
living upon this honorable court. This court, if the court is concerned, it is completely upon the convenience of this honorable court. The time permits you also better.
Well, let it detained in the list. Even I will not bother this court. If the time permits, let's go with it. Otherwise, this has to be taken in the next second.
Not today, not today.
Not today, just not.
Item 4, Advocate 14 of 2025.
I am there for the inspection.
Matter involves
But a scheme of regularization ought to have been extended to my client. That has not been done. That's one part. Airport Authority of India now claims
who is for the respondents?
service has been done. I can let it come tomorrow. Again, I'll serve it.
Andaman and Nicobar Administration,
Mother,
Deputy Commissioner, Eviction Officer,
Tahsildar.
Tehsildar.
Or let it come tomorrow. Let it come.
Not today.
It's not good.
Item 5, Advocate 19 of 2025.
Well, I have, there's an urgency. I've sought for dispensation of notice under Rule 26. Now, kindly see page 41 once. There's an extreme urgency. Tahsildar has fixed the deadline to evict me from the subject land. and a new color has been given to the order. If I go with the allegations,
Mr. Chakravarti represents the Andaman and Nicobar administration.
I'm appointed for a particular brief, my lord, I'm not standing also. Miss, it's the revenue department. Miss Babita Das usually learned government figure, she is usually the person who can take notice. Her junior is present in court, my lord. She can present herself.
Your Honor, authorities does not give an instruction, Your Honor, in this matter, whether service is there or not.
Ask your senior.
Yes, Your Honor.
Not today, 11,000.
just not today, ma'am, just not today.
Item TR 24,
The appears for the respondent state CBI.
I just pray this and accepted because he have gone to the medical. Took his father for the medical treatment, your doctor.
Item number
6-13, 6-2-13,
6, 7, 8, 9, 10, 11,
and 12 and 13.
12 and 13.
Yes, ma'am.
His name? Mr. Representing the
No, just.
We can argue.
No, I'm not. I'm only responding to the judgment that is cited. I'm not. We have concluded our submissions on the last.
That's what, responding means.
Respond mane only the judgment,
only
judgment.
the citation.
Now, my lord, this judgment, my lord, is not at all applicable, my lord, because my lord, this judgment, here, my lord, the question before the court was whether the provision of bail can be done away with in the special statute, in this case, the SC/ST Act. And the court has in fact, said that.
She has referred paragraph 7 and 23.
Yes. And
Yes. Now, kindly see. I have got the SCC, my lord. I don't know whether which paragraph of the SCC has been cited, but my lord will find, if my lord goes through the judgment, my lord will find that here the court said that bail is not, even if the provision of bail is done away with, the court has in fact rejected the argument relying upon right to life and said that even if bail provision is deleted from the statute in certain circumstances, special statutes may not provide for bail. So, my lord, this judgment doesn't help the petitioners at all, besides the fact that it is completely on a different factual situation. Some argument was raised, my lord, that bail is part of right to life. And therefore bail cannot be deleted by a statute which does not provide for bail of is a violation of the right to life. That argument has been rejected. So my lord, this judgment does not come to the aid at all. That is my only submission.
Human dignity, which has been
That
extended.
argument has been rejected in this case, my lord. It has been said that
The judgment is apt to to that particular.
Lord Counsel, what infringement as regards to legal right?
Article 21, because human dignity, everyone, it's mentioned in this judgment also. Everyone has a right to live in a peaceful and proper manner. That is a dignity which is given. If it is violated, then Article 21 will come into picture. Here, I am allowed to
In this
operate.
list,
In this list, here I am allowed, made to operate the shop in a thatched hut. And they have taken a decision that fruit market will be constructed. For that, funds have also been raised. That particular thing is to be implemented. I am asking for only that, because that is going to give me dignity. Why I should be made to pay the authority and to live in a thatched hut?
if you say so, Learned Counsel, if you say so, Learned Counsel, dignity, you were offered places in the Gandhi market.
That's what even the authorities have, I have mentioned,
No, you were offered, you were granted spaces
Yes.
in the Gandhi market.
When I.
Therein you did, in the second round of litigation,
Yes,
writ
I
application,
remember.
you have considered the fact that we will shift ourselves to the Gandhi market. In spite of that, you did not take the spaces which were granted by the Port Blair Municipal Council. You did not accept those spaces.
The municipal council itself has observed, your lordship, that if we go there, we will not be able to do any business. Because it is inside, it is not by the side of the road, where the fruit vendor sells fruit. It's not, it's the observation is there, by their own authority observation is there. After that only they have decided to open a fruit market in 2017. I am asking for implementation of their own agenda, their own decision. I'm not asking something else. 7 years have passed, but they have not done nothing. Even after taking a decision. And now they are coming with the point that what infringement? It is an infringement because Article 21 is clearly violated.
This one also, for orders.
my lord is keeping it on. Acha.
20th for orders.
Very well. My lord, my lord.
Nothing to be cited. Mr. Chakuti, nothing to be cited.
No, my lord.
These matters, two matters, being tried analogously, immediately taken up in the next circuit. I'll use my reply. The interim order needs to be extended. There's an interim order.
Correspondent manner, select them, Mr. Wilson.
Is the interim order still in existence?
Subsisting.
Subsisting.
Still subsisting.
I think it is expired.
Wherefrom it will reveal.
Even if it's expired, not can reinforce always, not always can reinforce it.
Lord Counsel, wherefrom it will reveal that it is still subsisting.
Because I've been appearing, Your Worship, time to time, it was extended, my lord.
Last occasion. interim order as passed earlier is extended till the last day of January 2025 or until further order, whichever is
No,
earlier.
so this thing is January circuit, this has to be extended till February. I'm liberty to file my reply.
You are representing all the respondents.
Yes, my lords.
Hmm. Hmm. Affidavit in reply not yet filed.
Just have the copy of
Uh,
opposition I'll use.
Learned counsel representing the.
But I am for the respondents.
Mr. Prashant appears for the petitioner, just not today, as per his,
Not to be. Ms. Das, one matter. Ms. Das, in one matter, in which Mr. Jaipal is the petitioner.
I'll take instruction.
You can take instruction.
Oh, yes. I've given the copy.
Yes.
I received the copy of the instruction. But in this matter, I have filed my affidavit in opposition whether yes, for the registry.
just not.
Kindly recorded that I have already filed my affidavit in opposition.
If you have filed, it will be in the
The
record.
registry it was filed.
Affidavit in
Copy
opposition
has
filed on behalf of the
accepted as-
respondents.
Mine.
Affidavit in opposition has been filed on behalf of the respondents. Let it be kept to the record.
It's not today, the instruction from Mr. Prashant, just not.
Full stop. In the paragraph, learned counsel representing the representing the petitioner. Prays for an accommodation for this day. Let the matter be listed on what is the date? 16. 16:1.
Okay.
18/6/2024.
I appear on behalf of respondent 1, 3, and 4.
I'm for two, my lordship, led by Mr. Vidi Shobana. There is
You are for the
the,
respondent.
yes, my lords. No,
I am
for,
standing with the petitioner. Be kind enough to be on this other side.
But there's no collusion though.
Seems to the.
There's no collusion.
there is a direction to file report, my lordship.
The report has already been
In
filed.
another matter, they have filed it.
May needs to be filed.
We need some time to file the report.
Wherein you have been granted the file report,
My lords,
by which order?
order dated 11th December, my lord.
Hmm. Within a fortnight from the date. Hmm.
In another matter, we have filed it, we are given for waiting, my lord. We need some time to what we did, we filed it.
Respondent number 2 is
Forest Department. It's
Learned Counsel representing the respondent number
the
2.
Chief Conservator of Forest. Degree हुआ ना last time.
Item 20, WPS 2024.
Lord, we have filed the opposition, my lord. Opposition has been filed, my lord. They want to file reply, my lord.
Intend to file reply.
Yes, madam. This may be given as the petition matter was expired, my lord.
The Learned Counsel representing the petitioner.
Item 21, WPS 689. Item 21.
I appear on behalf of official respondent, so private respondent. My lord has directed into.
On the earlier occasion, Mr. Arul Prasant was appearing for the petitioner.
Private respondent has not served.
Just not today. Prashant, just not.
Next circuit.
On this.
Kept today, just not today, just not.
Service on 7th of January, service
Yes.
has not yet been completed in respect of the private respondent number 2. On that ground,
I don't know that whether they had affected the service, just not today, there is an instruction form.
in one circuit, 3 adjournments. Either the matter be heard out or be placed to the next service.
Just not today.
Twenty-two, my lord, and 31 are connected matters. My lord, whether it be taken up at 22 or at 31. Opposition? Here, my lord, some Madras High Court, Madras High Court, whatever it's come. Yes, my lord, the issue, my lord, is, yes, thank you. Yes. Now, I'll just hand over this note, my lord, which has been prepared. The signed report, my lord, we can file an affidavit also on it. आपको दिया है ये?
नहीं, madam.
Let them respond to this, my lord. Here, my lord.
This manner, your lordship, why should I respond to all these things?
Very well, we'll
We
file.
don't know what is
We'll
the
file it,
reality.
come in the next session. Wait, maybe take. Not affidavit in opposition. This is, they have filed a can, my lord.
Okay.
First can.
We have filed the,
Can in?
Can in item number 31, can 4.
no, 22, item number 22, let us go one by one.
22.
Item number 22, it is not can, it's
22.
WP, they have to file opposition.
22 WPS 692 of 2024.
Yes.
File opposition, my lord. Let's say.
The council representing the.
opposition.
Same order.
Only thing is that in that, my lord, it is response to the can.
Yes,
Can
sir.
4.
Yes, can, they have to file.
Let that matter appear, let that matter
It's
appear.
connect, it should be heard together, my lord. Same issue.
Together.
Yes, same issue.
31 WPA 1103 of 2023.
Can 4, my lord. The response will be.
Can 2 of 2024 and can 4 of 2024.
Can
4.
Response will be in can 4.
There are 2 applications pending.
Can 4,
Can 4. Can
2
Can 4. Can 4.
from the cognizant file that.
Can 4 CPM, my lord.
The learned senior advocate representing the administration, submits. Yeah, what taking. After which. Do pause করুন।
Almost any appeals for petition in this matter. They have to file opposition. I've already filed opposition. I've been handing over a copy to her.
Item 23. 23. Yes. Hmm. You are representing the respondents. Have you filed Wakaranama?
I've filed my opposition and then.
When?
Serving copy to the. File reply to that.
Hmm.
But there's an interim model, till last year, this is that. I was.
Interim order till
Last year, this circuit. That time, mention we made on the last date. Here.
no learned council. White Beach order.
First, it's where the petitioner think of here personally.
Which paragraph? Which paragraph? It will be open for the respondent of the hearing. Gotcha. But the respondent authority is restrained from taking any coercive steps against the petitioner till the last date of the first circuit of 2025. The learned council. Affidavit in opposition
24, WPA 524.
If I am appearing for the respondent as per direction lordship, I have filed my opposition today.
Hmm.
I am serving a copy.
What new facts have been placed before through the affidavit in opposition? Whatever it be. Have you introduced a new fact?
No, lordship, her application has already been rejected, lordship.
So,
Kindly see, and kindly see page, 10, madam. This is the application I have filed, madam. This is the application I have filed, rejected on the ground that, kindly see page 13, madam. Remark columns. Page 13, madam,
Hmm.
to submit either ration card, electoral identity or mandatorily having the same address.
Hmm.
Sir, kindly turn the next page, madam, that is page 14.
Hmm.
The petitioner name is there. This is the ration card. This is the ration card wherein name is appearing, the same address is appearing. The same address. Kindly be seen, madam. Why they have rejected, madam? Then why they have rejected? The same address, everything is there. I have provided everything. In spite of that, they have not given me the electricity. This remarks has been given, madam.
Lordship, kindly see when the application has been made and when the document at page number 14 has been issued.
when the application has been made,
On 6 June 2024,
and when the ration card has been issued,
25 July 2024.
where from it will be.
Date of issuance, it is written, lordship, date of issuance.
Where it is. Date of issuance.
25/7/2024.
Where it is.
It is right side, lordship.
Yes, right.
Date
Date
of
of issuance,
Yes,
25/7.
But I'm residing in the same place and I'm residing in the same place. I have
Learned
enrolled
counsel,
prior to 1990.
learned counsel give reply to the question issue which has been raised on behalf of the opposite party.
I'll come with the instructions. tomorrow.
Nil.
Day after
It is being disposed of.
Day after tomorrow.
It is being disposed of, learned counsel.
Yes, receive the affidavit in operation, have to.
What new fact? Have you introduced a new fact?
no.
They have given several documents they have given.
Judgments we have placed,
Several documents.
judgment of larger bench,
Many documents are there. Let it be
Judgment.
there tomorrow, I'll satisfy this court.
your lordship has already dismissed one writ application in the name of Kavita.
The application, one has been dismissed, that doesn't mean that every application has.
Learned counsel, why are you,
Every application has to be dismissed.
what has been done in respect of one, can it be done in respect of the other also?
That only.
What have you filed? You filed authorities.
Yes, sir.
That is, one is
Larger bench decision of this honorable court.
yes. That is known to each and everybody. Why have you filed this one?
Lordship,
From 1992, I'm there.
Is this a new one?
no.
No, I'm in second position.
Is this judgment a
As
new?
per this judgment, I'm in second position, my lord. This judgment speaks like that, my lord. If I'm in second position, I should be provided with the electricity.
So, do you intend to file affidavit in reply against this judgment? So what do you intend? So what do you intend
In operation, my lord, and with regard to this.
tomorrow?
Tomorrow. Okay.
Why have you filed these judgments?
Lordship, actually, I have sent it for waiting to the law department. They have included, so I cannot strike down. So I have filed it.
Who will guide them? They will guide you or you will guide them? And the other one?
Godavarman case.
Tomorrow. Affidavit in opposition.
Item 25.
Lordship, I have filed my opposition, Lordship, I am serving the copy to other side.
Why haven't you served earlier?
Today itself I have filed, Lordship, so.
Why were you sitting with the affidavit in opposition? You could have served during the morning only. And to file affidavit in reply against judgments tomorrow. Same order tomorrow. Matters will be taken up tomorrow, otherwise the matters will be dealt with in accordance with merit.
Item 26, rule 36 or 122.
I am appearing for the respondent. Lordship.
Who is for the petitioner?
Mr. K. Sabir.
None is representing the petitioner. Is required to be filed.
Opposition is required to be filed, but no liberty has been prayed for.
No,
by the-
no liberty has been prayed for. As such, it will be taken up tomorrow.
Item 27, W3 007
27, 28, 29, just today morning I have received the copy from the other side, Lordship. So let me take instruction and come back in the next circuit bench.
The last day, there is a direction. This honorable saw the copy, so on that day, nothing.
This order was of 9th January 2025. The learned counsel representing the petitioner submits that he will serve the copy of this petition to the learned counsel representing the respondents during the course of this day.
For this item, unable to saw the copy. Thereafter, he is not telling by virtual mode he appears. Twice.
Next circuit. The learned counsel representing the petition.
Item 29.
Same.
Item 30.
Same order.
Here also I require time to file my opposition.
I am appearing for the writ petition.
On 9th of January, you sought for accommodation for
To
this
take
day only.
instruction, Lordship.
No, for this day only. On 10th January, on consent of both sides, let the matter be taken up on 13th of January. Learned counsel,
Lordship.
let us take up the matter.
Lordship.
My lord, in this matter, I am appearing for the writ petitioner. The writ petitioner herein has made an application before the respondent number 2. The same is on page number 12, my lord. For grant of electricity connection. My lord. No, the application has been made on 8th January 2024, a year back, my lord.
Page number
12, my lord.
12 contains the
Application made by the writ petitioner for grant of electricity connection.
go through the application in page number 12.
Small mistake, my lord.
In which page is the application? Page number 11. Yes. When did you apply?
Applied on 8th January 2024, my lord.
Being an encroacher
My lord.
on which land?
My lord, this landed property has been encroached by
On which
my
land?
grandfather,
On which land?
government revenue.
Yes.
Government revenue land, I have made an application, my lord, but till date, the application has not been considered, my lord.
When have you made?
On January 8, 2024.
What were you doing during this Idnaragna period?
My lord, I approached the respondent authority, my lord. They on the context that it is forwarding to J and E. My lords can see in the application on page number line 11 also. There's a marking of to the J concern. So all
JE
this
means
junior intern,
junior?
engineer.
Hmm.
So altogether, they have made assurance that it will be granted, but till date, it has not been granted.
Learned council upon which land?
But if land status, the authority cannot decide. It is the authority. It is the revenue authority who can say that.
Have you got go to page number 11? The endorsement?
Lordship, original copy is lying with him. How it is possible, Lordship?
I have made a same
Yes,
Original
furnished,
copy
yes,
of the
furnished the
department. Original copy of the department. How?
and endorsement has been made, my lord, to application has been served. My lord, I have made the application.
Yes. What are you submitting?
Lordship, original copy which was submitted before the authorities lying in the petition of the
My lord, not my lord.
How can
writ
that be?
petition.
How can that
I
be?
have seen, Lordship. It is
My
here
lord.
only.
In my application.
How can that be?
I do not know that is from where he has got this.
No, my lord. Application has been made before the response.
Show him which one he is stating so.
The department document.
Not actually, original copies are lying with the department. It has been marked to the department, respondent authority to ascertain. And same is done, but
I have to file opposition lordship because without opposition, original copy of the application is lying in his file.
it is lying on the
The
department.
matter is fixed on tomorrow.
Lordship,
Receive instruction.
this is pertaining to Neela lordship. Let it be day after tomorrow, lordship. I will,
Day after tomorrow.
lordship.
Nothing apart from that one, whether the application has been filed or not.
Yes, madam.
Mhm. The learned counsel representing the opposite party respondent. Whatever to be done, learned counsel, do it today itself.
Lordship, lordship.
Article 32, 67 of 24.
I have done with the
Citations?
citations.
No, citation.
You know, to be added.
The contention of the appellant.
Yes.
Contention of the appellant is that nothing unparliamentary nor any such word has been used in the notices. And the notices bear only the facts, nothing derogatory,
I am going to marry, is it a fact? That's what,
according to
I
the,
can
according to
understand.
the appellant.
Yes. That's what, in response to that, I am only submitting. Your Lordship, I am reading the notice again, page number 107. Under instruction from my client Srimati Ananta, wife of Shri Ramchandar, it is brought to the notice of general public that my client's husband Shri Ramchandar, son of this, who is presently holding the post of assistant engineer under Port Blair Municipal Council, Port Blair, filed a matrimonial suit bearing MAT suit number this before the Court of District Judge, Port Blair, praying for decree of divorce against my said client on the alleged ground of cruelty and desertion. On 14/7/2008, the Learned District Judge, Port Blair, allowed the divorce petition of Shri Ramchandra, thereby dissolving the marriage tie between Ramchandra and my said client, Srimati Ananta, wife of this. Challenging the said judgment decree dated this, my client preferred first appeal bearing number this before the Honorable Division Bench Circuit Bench at Port Blair, which ultimately was allowed on this, whereby the Honorable High Court was pleased to allow the appeal of my said client and thereby set aside impugned judgment decree and dismiss the suit filed by Ramchandra before the Learned District Judge, Port Blair. Up to this, it's nothing, no problem at all. Thereafter also, if she had written that anybody who is interested to marry Ramchandar may be aware of this particular fact, that also would not have harmed me. But what is written thereafter? It has now been learned from reliable sources by Srimati Ananta that her husband is trying to marry another girl, in contrary to law by which both my client and said Ramchandar are governed. Such marriage, if conducted, shall be illegal in the eye of law, and the marriage, if any conducted, shall be not valid and will not confer legal status to the girl. I am not concerned with other parts, Ilmisha. I am only concerned with this particular line, that it is now learned that he is trying to marry another girl. Now, in order to prove that that is defamatory, Your Lordship, I have produced evidence. Apart from PW1, there was another 2-3 persons who have been examined, who have specifically stated that after reading that contents, what they have done. Page number 41. Page number 41. He is working in the same department because, Your Lordship, the defamation can occur only in respect of a person who is acquainted with that particular person. He cannot be a stranger. Stranger has got nothing to do with me. But a person who is acquainted with me, only he can say that what impression he has got after reading the newspaper. Paragraph 3. I say that I came across an article in the newspaper, namely the Daily Telegrams on this, wherein it was stated that the plaintiff is trying to marry another girl in contrary to law, and if such marriage is conducted, the same shall be illegal and unlawful. I say that earlier I used to have very high thinking about the plaintiff. After going to the contents of the newspaper, his image was lower down before me. Whenever I faced him, I used to recollect the contents of the news item and I used to think ill about him. I used to think that how this man could contact second marriage during the subsistence of the first marriage. I used to think that he might had illicit affair prior to filing of application of divorce, and that is the reason why such materials have been published in the newspaper. I say that I do not know the truth in the newspaper, but being an employee in the department, I know that gossips about the contents of the news item used to be made between the employees, and majority of the employees used to speak ill about the plaintiff after reading the news item. I say that news item has tarnished the image of the plaintiff amongst the colleagues. I say that I could not give such respect to the plaintiff as I used to give earlier before the publication of news item. I say that I found difference in the attitude and behavior of the other employees of the department. Even they used to wish the plaintiff seldom. So he has stated after reading the newspaper what impression he has got. He's working in the same department and what was his opinion. Now the cross examination may be seen. Page number 44.
Yes.
Yes, the plaintiff and the witness work in the same department. Yes, they are husband and wife. Yes, they are husband and wife and no knowledge about their friendly relationship. My opinion about the legalness of marriage is not false. Legality of marriage is not false. No, I have no knowledge about the fact that plaintiff files many cases before the Honorable High Court against municipal council. Nor that the plaintiff is not a reputed person. Not that the reputation became then not a fact that I adduced falsely as I was subordinate to him. By this cross-examination, what he deposed before the learned trial court could not be impeached, Your Lordship. Because nothing new fact has come, only not a fact. And the fact that he is working in the same department has not been disputed. He is working. And the person who is working along with him can only say about him that what he is thinking, what he has thought about him after reading the newspaper. Now, next person, PW3. The examination in chief of PW3 is missing from this. Chief is not there. Mohammed Rafi का chief नहीं है. हाँ होगा. देखो मेरा उसका होगा जो अच्छा Mohammed Rafi का chief है. I have gone through the entire evidence here, Honor. Your Lordship, nothing is
Provide the evidence.
I'm just placing it. That I am working as a driver in the department of Port Blair Municipal Council. I can read and understand English language. That daily I read newspaper, and during reading the newspaper, twice I came across a notice in the newspaper, namely the daily telegrams, sometimes on this and this, wherein it was stated that Sri Ramchandra is trying to marry another girl in contrary to law, and if such marriage is conducted, the same shall be illegal and unlawful. That apart from me, the said notice was read by a number of persons known to me. After reading that notice, people and staff of our office used to talk about the character of Sri Ramchandra. Earlier, I and even the other staffs of our office used to think high about Sri Ramchandra. After going through the contents of the notice, his image was lowered down before me and before other people known to me and who had spoken about Sri Ramchandra. Whenever I faced Sri Ramchandra, I used to recollect the contents of the news item, and I used to think ill about him. I used to think how this man could contact second marriage during the subsistence of the first marriage. I and a number of persons of our office used to think and talk that he might had illicit affair prior to filing of the case of divorce, and that's why such notice has been published in the newspaper. I cannot say the truth in the newspaper, but being an employee in the department, I know that gossips about the contents of the news item used to be made between employees, and majority of the employees used to feel ill about this. The news item has tarnished the image, and same thing. Then he has what impression he has got about this particular person, that has been stated. Now cross-examination. Cross-examination. My qualification in 9th pass. Khalil Rahman, MS Akbar are my two elder brothers. A.S. Zeno, practicing advocate of this court, is a daughter of my brother MS Akbar. Shivpati Devi is the mother of A.S. Zeno. I do not know whether learned advocate Ajri Nag is contesting the case of the mother of A.S. Zeno. I am a heavy vehicle driver of water tanker. Not a fact that my statement in this, my examination are totally false. Zaki Ahmed is assistant engineer of PBMC. I know Zaki Ahmed and plaintiff Ramchandar. I do not know whether there is any dispute between them or not. I know the plaintiff at least since last 10 years. I know Zaki Ahmed when he was posted in our department. One Matthew Varghese also read the contents of the newspaper dated this and this. Matthew Varghese is worker under mechanical section. The plaintiff is assistant engineer in electrical section of municipal council. I do not know the ground of the divorce filed by the plaintiff against the defendant. I also do not know the fate of that divorce suit. My wife Zubaida Begum was a chairman of the Port Blair Municipal Council. I do not know whether any dispute has been disposed of by Honorable High Court or not. I also cannot say whether there is any dispute pending in between the plaintiff and the defendant before the Honorable Supreme Court of India. I read out the fact displayed in the newspaper on this. The divorce order passed by the was set aside by the Honorable High Court. I do not know whether one Jaya is the PA of the plaintiff or not. I cannot remember whether it was in the publication that order passed by the Honorable High Court has been challenged by the plaintiff before the Honorable Supreme Court. What respect I had for the plaintiff prior to reading the newspaper, I do not pay such respect to him at present. Your Lordship, this is very important. It is coming in the cross-examination. My opinion is that government officers should not marry for the second time during the existence of the first marital status. I also think that the plaintiff is characterless. I cannot say that the opinion of my colleague, namely Matthew Varghese, who also read the newspaper of the relevant days. Not a fact that there was no publication. This is not a fact. My opinion as well as opinion of Matthew.
The other items except the in respect of second appeal. This one is second appeal 1 of 2025.
then nothing more, nothing's important. So both the witnesses have specifically stated what they felt after reading the newspaper. Your Lordship,
Learned counsel, do you have any hindrance in continuing?
no, Your Lordship. But if Your Lordship
No.
feels, because Your Lordship is sitting since,
Yes, no.
since morning.
I'm,
We are standing, it's no problem. But
I am
so, Your Lordship, what my submission is that I can understand if a caution is given. Caution is given, the divorce decree has been passed, which has been set aside by the Honorable High Court. Now he is considered as a married man. So anybody who is interested to,
Acha, one thing, this notices were on third and fourth, third
third
and
and
fifth,
fifth,
third and fifth of December 2008.
8.
1 minute. Yes, 3rd of December 2008, 5th of December 2008.
Yes.
First appeal judgment reversing the trial court judgment was passed on 24/11/2008.
Yes, ma'am.
Your Lordship.
Divorce.
Yes. So after the passing of the FA. Yes.
So what my contention is that if a caution is given, people, Your Lordship, we have to consider this particular news item by the eyes of a common man. How the common man will take into consideration this type of sentence, that we have to consider. And that is what has been done by the appellate court. By reading this, Ramchandra is, I have come to know from a reliable sources that he is trying to marry another girl. What is the meaning of that? And where is that source? Have you adduced any evidence to show that source? She herself appeared, deposed, that's it. Not even a single person was brought to the dock to say that, yes, I know that he was trying to marry this particular girl. And I have informed her about that. I can understand. Let it be false also, but she will be safe. If suppose somebody has come before the court and said, yes, I was the person who has informed her about this particular person, that he is trying to contact marriage, then in that case, at least the information what she has received, she has produced in the newspaper. There can be a defense of that kind, though that defense is not so strong, but it can be there. Here she has not even adduced a single witness. So what is from where she got that particular information that the petitioner is trying to contact second marriage?
Source has not been produced.
Not produced. Now, if suppose any of us, Your Lordship, if that type of publication is there, whether it is not damaging our reputation. Now that divorce has taken place, now divorce has order has been passed. The second round of litigation, the Honorable High Court has already passed the divorce decree. Parties are divorced now. A review application has been filed, it is pending. But divorce has taken place.
1 minute.
They went,
Order of divorce was passed by the trial court.
First round, trial court passed, High Court reversed,
Reversed.
Supreme Court affirmed. Second again divorce.
Affirmed the judgment of the first appeal.
Yes. Second time.
So after first round of litigation, no divorce.
No divorce.
No divorce.
Second, new facts, new circumstances were there, new facts emerged after the order was passed. There was again dispute between the parties. There were again certain circumstances. Again, a divorce case was filed.
Mr. Jaipal, this was not
this
submitted.
was not the material before the present suit.
Why not?
This was not the
This has
material.
to be known to the court.
Mr. Jaipal,
This was not the material before the trial court.
whether it be a fact, whether that be a material or not, that is a fact.
Yes.
That has to be placed before the court.
Yeah, but this is not relevancy.
No.
This is
Mr.
not relevancy.
No, Mr. Jaipal.
No, divorce is have no relevancy
I
at
do
least
not-
for the
I
for
do-
this purpose,
I
limited
do not
purpose.
appreciate that. This court does not appreciate that one. The fact should be laid before the court.
No, I'm not concealing nothing, Your Lordship. This is a fact. I've said Supreme Court they lost. It's a fact. I don't dispute it.
Court क्या-
And this was not material in the damage.
So
proof.
learned counsel, Mrs. Nag, you will have to place about the second round.
Yes, your lordship, order है. Order है. So first round of litigation ended in dismissal of the divorce. Second, I filed a divorce petition again before the trial court.
The junior was not, is not aware of the fact.
No, your lordship, he was not there in the trial court. That's a difficulty. Because now they are coming up, your lordship. So we are,
So the second round of litigation will have to be apprised to the court.
yes, your lordship. Now, second round of litigation, there were certain new facts in the case.
Hmm.
It was projected to the trial court. Trial court did not consider it, rejected it.
Hmm. Trial court rejected.
Yes. That better to notes here. Then appeal was filed before the Honorable High Court,
Hmm.
first appeal,
Hmm.
and it was decreed. Divorce was granted.
Agreed.
After that, a review application was filed by the wife, and the said review application is pending. No stay, nothing. Only review application has been filed, it's pending.
Review has been filed by the wife.
Wife. Divorce, decree of divorce was granted
Hmm.
to the husband,
Hmm.
so she filed a review application.
Yes.
My point is that, your lordship,
Hmm.
that when these things have, when a person is publishing a news item, he should consider that by publishing such news item, somebody respect should not be tarnished. That type of statement should not be made. Government servant trying to contact a second marriage, he is an assistant engineer in the department, a reputed person. If you're writing like this, then what would be the result of this? Your lordship may kindly see that in the first round of litigation up to the went up to the Honorable Supreme Court. No case was filed for restitution of conjugal rights. She never filed. During these many years, she never filed any case of restitution of conjugal rights. She was contesting the divorce case, but never filed it. I know, your lordship, that is not going to help me in any way, but I am just showing the conduct, that what is her intention. Her intention was always to see that this particular petitioner is harmed in one or the other way. So when this publication was made, after 2 times, your lordship, because I have produced witnesses to show that image has been tarnished. PW1, the plaintiff was examined. PW2, one lineman of the department was examined. PW3, one more person working in the department was examined, because, your lordship, so far as the working people are concerned, their image and respect is considered within the periphery of their official circumstances. Social gathering and all those things, your lordship, would come secondary. But office, your lordship, people meet each other every day. So office people, they give respect and they give regard to the other person. So those persons who are working in the office, when they are coming to the court and submitting that, yes, by reading the newspaper, they felt like that, then we can imagine about other persons how they might have thought. So this was looked into by the First Appellate Court. First Appellate Court went deep into the issue, and your lordship would see that how the findings have arrived by the First Appellate Court. It is really marvelous. He has taken into consideration old judgments and all those things have been considered. Now, if the quantification of the thing is, it's a discretion of the court, because reputation, tarnishing of reputation cannot be quantified. It's next to impossible. So how you will calculate? It's upon the discretion of the court, considering the reputation, considering the position of a party. The court comes to a conclusion of rupees 2 lakhs. If he says that it is to be reduced to 50,000, I have no objection. Really, I have no objection. I just wanted, my client just wanted to show that that by her act, he has been disrespected, his image has been lowered down. And this is defamatory. That's it. Just a minute. दिमाग में यूज किया करो भाई, रिव्यू डाला है, रिव्यू में जजमेंट जरूर होएगा। Your Lordship, I'm just placing the judgment of the divorce, it was granted on 24th August 2023. I'm just placing that judgment. I'll provide a copy. We have heard the respective parties separately and thereafter jointly in chamber on 18th August 2023. The parties sought time for further deliberation. Today, learned advocate representing respondent wife submits that his client is not interested in any mutual settlement and the matter may be heard and decided on merits. The court has heard the learned advocate representing the respective parties at length and has perused the materials on record. It appears that repeated attempts for settlement of disputes amongst the parties and consistent efforts of reconciliation have failed. The parties are living separately for nearly 18 years by now. The son of the party who has presently attained majority is all along residing with the husband. While speaking to the parties, we notice that there is absolutely no scope for a patch-up. There is neither any emotional attachment nor financial dependency upon each other. None has any feeling for the other. Both the parties are working and have a fair amount of income. The wife has categorically submitted that she is not agreeable to accept even a single penny from her husband. She is in fact earning more than her husband. The salary is more than her husband. Though the wife submitted she is interested to live with her husband, but at the time of interaction in the chamber, we have noticed that parties were not even looking eye to eye with each other. None could tolerate the presence of the other. Both cast aspersions and leveled several allegations against each other. Apart from a formal submission that she was willing to live with her husband, there does not appear any genuine effort to actually do so. The wife appears to be really under a misconception that the husband and the son will at one point of time return to her. The wife is also holding an impression that if the husband is successful in obtaining an order of divorce, then she would lose the legal battle which is continuing from the year 2005. The wife intends to prolong the legal tussle and does not want to relieve the husband from the marital tie. The wife has taken the litigation as a game competition and is hell-bent to win the same under any cost. In the course of discussion with the parties, it appears that neither the husband and nor the son can accept the wife oblique mother. The husband has clearly stated that presence of his wife in the house may be a matter of concern to him and his son, and any untoward incident may happen anytime. In such situation, passing a judgment in the matter only on legal points will be an empty formality. The marriage has broken down irretrievably, and prolonging the matter further will amount to cruelty, harassment, and pain to both the parties. When the parties have lost their reasoning to stay together, no legal discourse can save the marriage. The only option left to the court at this stage is to break the marriage in the interest of justice and to prevent any further injustice to the parties and their son. In view of the above, we think it proper to sever the marital tie and dispose the pending appeal. The marriage of the parties held on this accordingly stands dissolved on and from today this. The impugned judgment and decree of this are set aside, the appeal is disposed of.
On the ground of irretrievable breakdown of marriage.
And irretrievable breakdown of
On the
marriage?
ground of irretrievable
Yes,
breakdown of marriage.
basically irretrievable breakdown of marriage. But the Honorable High Court has noticed the conduct of the wife. Specific that one paragraph is there, the wife appears to be reeling under a misconception and then all these things. Even the Honorable High Court has noticed that.
This one is judgment passed in
FAT 1 of 21.
FAT
Yes.
1 of 21. 2021. Dated
24th August
24th August
2023. I just want to show one.
a hard copy of the
I will
judgment.
throw
is
it. I will throw it. Yes, I'm sorry, Your Lordship, I missed one thing. The defense witness, there were witnesses, but none of the witnesses have deposed that they have stated that the plaintiff was trying to marry another person, another lady. They have not named that lady, but nowhere they have stated, they have informed this particular fact to the defendant.
The DWs.
DWs. No one has stated. First of all, they have not named to whom the plaintiff was going to get married. They have not named. I know Ramchandar, who is working as assistant engineer. It has come to my knowledge in the last month of year 2008 that the said Ramchandar was trying to get married with another lady during the subsistence of marriage between himself and another. Such fact was informed to me by some of my friends. Very peculiar thing. The DW2, though I have mentioned in my examination in chief that in the month of December 2008, I came to know that the plaintiff was going to marry. Page number 63. Page number 63, though
Yes.
I have mentioned.
Though I have mentioned in my examination in chief.
That in the month of December 2008, I came to know that the plaintiff was going to marry, but my knowledge I acquired in fact in the month of January 2009. Then how the publication could be made on 3rd December and 5th December? This itself shows these are tutored victims. And they have never said, kindly see, I did not tell the matter to the defendant that I came to learn the plaintiff was going to marry. Straight answer. I did not tell the matter. Because somebody should have informed her from reliable. This is not the source. He is not the source. One thing is very clear. He is not the source. Then DW3, same thing. And this particular lady, that particular lady whose name was Saswati Roy or not, nobody knows. Because she was not a summoned witness. She was brought directly to the court, filed examination in chief. Nothing, no document was exhibited through her that her name is Saswati Roy. Her identity was not at all proved.
Either in the first round of litigation or in the second round of litigation, any third party has been made party in the first round of matrimonial dispute or in the second round
No.
of matrimonial dispute?
No,
Any third person?
no. No third party was a party to the case. So the evidence of these witnesses, because so far as Saswati Ray is concerned, even she did not say even she did not say that she has informed the defendant about that particular fact. She repeated what has been stated by DW2, that she came to know about the fact that Ramchandra is going to contact second marriage from certain friends. She has stated that. Who are those friends with whom he was going to marry? Nothing is there in the examination in chief. And she was unable to produce any document to show that she is actually Saswati Ray. No document has been produced. So my submission is that when the source, because defamation, if someone is publishing true things, there is no defamation. But if someone is publishing false things, and which is prima facie, Your Lordship, apparently on the face of it, by reading by a common man, appears to be defamatory, appears to be to tarnish the image of a particular person, then it amounts to defamation. And the entire evidence, because appellate court has considered the entire evidence. This is a finding and opinion of the court, Your Lordship. Your Lordship knows that in second appeal, the finding, the opinion of the court, if there is two opinion possible, the appellate court's opinion, Your Lordship, just because the opinion is not to be, there is possibility of another opinion, this opinion should not be taken into consideration. That cannot be done in the second appeal. Law is settled to that effect. Court, the first appellate court is of the opinion that these statements are defamatory in nature. And on the basis of the evidence led by the parties, the court has come to this particular conclusion. There is no evidence whereby they are able to show that what they have stated in the newspaper, what they have published, that is true. They were not able to show that. Your Lordship, so far as kindly see the second appeal framing of question, the first question. First question, very
Page number.
page number 203, first question. Yes. Whether a publication that the appellant is a legally wedded wife and no lady should contract the marriage with the respondent amounts to stigmatize the reputation and prestige of the respondents before the general public. Your Lordship, this was not the publication. Had this been the publication, I would not have filed the case. This kindly see, this is not the publication. Ramchandar is trying to contact second marriage, and therefore caution has been given. If only after the judgment, if only this was the publication, there was no defamation at all. That is the truth. One person got the divorce, thereafter it was set aside by the Honorable High Court, information is given.
So according to you, there was no caution. Instead, there was publication that he is going to marry.
Yes, he's trying to marry somebody else. From relevant source we have come to know. And therefore, the general public is cautioned. Why? General public can be cautioned in normal way also. Why these things should be written? So first question, practically this is not the publication at all. The main point of publication is he's trying to contact second marriage.
Page 10,
Just
the publication,
yes.
107.
5 and 7.
So
It has now been.
what hurts you is that Ramchandar is trying to marry another girl. This hurts you.
Yes. And from reliable sources, she has come to know. It has now been learned from reliable source by Srimati Ananta that her said husband is trying to marry another girl. While getting this second appeal admitted, only the last part of the order was read. That caution has been given to the public in general. And the second one, Your Lordship, I am leaving upon this honorable court.
Quantity.
I am leaving upon this honorable court. I am
Yeah.
not interested in money, Your Lordship. My reputation has been tarnished. If that is found to be defamatory, it is sufficient. I am not interested in the amount. So I am leaving upon this honorable court, whatever amount this honorable court finds it appropriate. If the first question is answered in positive, means in my favor, then the quantification I am leaving upon this honorable. Judgment. Okay.
Citations.
Your Lordship, this is 1994, volume 6, SCC 632, paragraph 21, 24 to 29. Many judgments have been relied upon by the first appellate court, Your Lordship.
1994, 6 SCC 632.
Yes, Your Lordship. Many judgments have been relied upon by the appellate court. So I am not giving the hard copy of those because discussion is there in that judgment itself. Paragraph 21, 24.
Paragraph 21 and 24 to 29.
Yes.
Mr. Jaipal,
No judgment.
no citation. Yes.
That's all.
So, and first of all, I beg your pardon, because the entire publications relates to the first round of litigation, 2008. There is no intention to conceal any facts, because I was the counsel from day one. There cannot be any, I understand, but everything could have been placed.
What to be let down?
Absolutely, absolutely. Everything could have been, I'm so sorry for that. I'm so sorry.
Complete?
It's complete.
Heard the learned counsel representing the